Gentlemen, good morning, ladies and gentlemen. This meeting of the California High-Speed Rail Authority Board will come to order. The Secretary, please call the roll.
Vice Chair Schenk. Vice Chair Richards.
Here.
Mr. Umberg.
Here.
Mr. Burns. Mr. Hartnett.
Here.
Mr. Balganorth.
Here.
Mr. Rossi. Chairman Richard.
Here. Vice Chair Richards, would you please lead us on the Pledge of Allegiance?
Please stand.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Ladies and gentlemen, two administrative items before we start. First, I've been informed that there was a typographical error in the agenda that was handed out. It was dated yesterday, the 19th, instead of the 20th. I'm also informed that new corrected copies are on their way to the auditorium when they come in. Ms. Moore will have them. And I understand there's also some numbering corrections on them. Also, item 5, the approval of the amendment to regional consulting contracts will be pulled from today's agenda and dealt with in a different manner. So with that, why don't we... Okay, Mr. Felenz points out that the correct agenda was posted online, and that was correct.
We just failed to bring it here.
Right, but we brought the wrong one. Okay. The public comment period, I'm sorry, just one second. So we're combining public comment for the... right. So we'll do public comment on that. But are we doing public comment on both of those?
Yes. Okay. So
it's public comment for items 1 and 1 through 4.
Okay.
And then we'll do general public comment. Okay. I apologize. We do have today an action on very important environmental documents, and so we'd like to make a slight change in the public comment participation structure. So we have agenda items 1 through 4, which relate to the consideration of resolutions to rescind the Bay Area to Central Valley revised final program EIR, then to receive a staff presentation, and then to consider the adoption, the certification of a new partially revised final program EIR. What we'd like to do is I'm going to ask our General Counsel, Mr. Felenz, to present on this item, and then we'd like to bifurcate the public comment period. We would appreciate it to first have public comments on those items alone. After that, after the board takes action on those items, we will then have public comment for the rest of the agenda. Mr. Felenz.
thank you, Chairman Richard, and board members. As you can see, agenda item number 1 is for consideration of a resolution that would rescind the board's prior resolution, number 11-11 from September 2010. The agenda item was carried over from the last week's board meeting. So agenda items 1 through 4 are all related to this Bay Area to Central Valley program EIR. The board will first take up the question of rescinding the old decisions, then there'll be public comment, and then after the board has taken up the question of the rescission, it will be necessary for you to take a step back and consider with an open mind the new decisions that you're about to take place for items 2 through 4, which includes all consideration of the public comments that you'll be receiving during the public comment period. You'll then be asked to consider the whole record before you, including the analysis from 2008, 2010, and 2012, in making a new decision in good faith and with your independent judgment. And what prior boards have decided is relevant information, but it shouldn't govern your decision. So item number 1, the resolution before you is straightforward. It would rescind the certification of the 2010 revised program EIR and the prior approval of the Pacheco Pass Network alternative and actions taken under CEQA. The authority was ordered to rescind these decisions in the Town of Atherton litigation. And as you are aware, since I forwarded this to you, there has been appeal filed in that litigation, meaning that you don't technically have to take the action to rescind those decisions today, but you can still do so and still comply with CEQA. After taking the action on number 1, assuming that you do so, you will then take up the questions of whether to certify the 2012 partially revised final EIR and make your decisions about which network alternative to select.
All right.
Okay.
I'm sorry?
And with that, I'm going to allow the chair to conduct the item number 2, which is the public comment
Right.
on this environmental document.
Thank you for allowing me to do that.
So you need to take action on this first rescission.
Right, on the rescission. Okay, so, and I'm sorry, folks who are following along at home, but we're trying to be precise about compliance with judicial rulings and so forth, so we want to do this in the right way. Pursuant to ruling in the Atherton cases that has just been made available from the courts, the issue, the authority is really directed to rescind its priorly approved program level EIR. And we need to do that first and as a matter of legal compliance, and then we will open up for a staff presentation and public comment and deliberation. Mr. Hartnett.
Mr. Chair, I want to be clear. On the agenda item 1, the rescission issue, don't we have to give the opportunity for public comment on that before we actually...
Well, that's what I thought.
No,
I just
it's
want to
only
be...
for the rescission. We're starting out with the decision on the rescission itself.
Right.
Yeah,
So you make the decision.
It would seem to me, as a non-practicing attorney, that if the court has directed us to rescind that EIR, I suppose we can take public comment on it, but we have to comply with a court order. So, do you want to...
based upon the information available and the court's ruling, I'm happy to make the motion, adopt the resolution rescinding. I just want to make sure that we're in the proper sequence.
I agree with that. Mr. Flens, can we ask the AG's counsel to come up and guide us on this? Well?
Certainly, you are welcome to take public comment if there are any comment cards on this particular agenda item before you take action.
Well, there is a comment card actually on item 1 that I see. Actually, a couple of them. So,
Okay. Why don't you do that? You can take public comment.
I will take public comment. Counsel, is there any reason not to take public comment on items 1 through 4 at this time, or should I separate that? Just one. Okay. All right. First, just to let people know, we take speakers in the order in which their speaker cards are turned in, with the exception that we generally ask our public officials and elected officials to speak first as representatives of the community. In this case, I have gone through the stack of speaker cards and pulled out, in order that they were received, those cards that appeared to be related to items 1 through 4. I have in front of me only 2 speaker comments for item 1. And so I'm going to call both of those at this point. If there's anybody else who wishes to speak on that item, please let us know right now. First is Mr. Stuart Flashman, and he'll be followed by Mark Powell.
Just to clarify.
Yes, Mr. Umberg.
So we have no choice in this matter, correct?
That's correct.
All right.
Since we're sworn to uphold the law, I would say we have no choice. Right.
Thank you, Chair Richard and board members. And actually, you do have a choice, and your counsel had just identified that since an appeal has been filed, technically, and particularly if you decide to file a cross appeal, you could say, well, we're not sure what the final court judgment is going to be, and therefore we're going to hold off taking any action on this until we know what the final outcome of the appeal and potentially cross appeal is. I would not advise that. And let me explain why. And that is because essentially this program EIR is a foundation on which you're going to base project-level decisions, and not only in this section, but also in other sections of particularly in the Fresno to Merced section, there is a reliance on a decision on the program level in this section in making the decision on the Fresno to Merced section. If you were to not rescind and keep the prior decisions, and the court eventually decided that the trial court was correct, or for that matter that the plaintiffs were in fact correct in their appeal and there were even additional deficiencies, if you left that in place, anything you did between now and when that happened would be like building on a flawed foundation. And if the foundation gives way, so does everything else above it. So my recommendation would be that you rescind the approvals that you gave and then consider what you do next. Thank you.
Okay. Thank you, Mr. Flashman. And in fact, I appreciate that because that is consistent with our understanding was that once the appeal was filed, we did not have to necessarily take this action today. Mark Powell?
My comment will go down a little better with item number 5.
Okay. We're down for item number 1.
Yeah,
but
that was just general comments at the beginning.
Okay. Thank you, Mr. Powell. One more second. Okay. That completes the public comments on this particular item. Mr. Flores?
For item number 1.
Yes, on item number 1.
So now the board can consider, deliberate on item number 1.
Right. So at this point, Vice Chair Richards?
For a comment?
Oh, I'm sorry. I didn't know if you were seeking to be recognized.
Yes, I just had one question, and it's just a matter of clarification, Mr. Flins. Mm-hmm. On page 2 of your staff report, where it says that the attached draft resolution provides the legal mechanism by which the authority can comply with one component of the final court papers. So there are other things that we need to do to comply with the final court papers. The rescission is just one of those.
Yes. This is just one.
Okay. So I assume the other work that we've done since then is also in furtherance of complying with the court papers?
Yes.
Okay.
That would be the environmental, the revised document.
Yes, okay. Yes. Thank you.
So the 1 point would be rescind, and then the next would be fix the document.
Okay. Thank you.
Mm-hmm.
Okay. Mr. Hart?
Yes, I move we adopt the resolution as presented.
Second.
Okay. It has been moved by Mr. Hartnett and seconded by Mr. Balganorth that the board adopt the resolution as presented to rescind to be precise, to rescind the revised final program EIR. Secretary, please call the roll.
Vice Chair Richards?
Yes.
Mr. Umberg?
Aye.
Mr. Hartnett?
Yes.
Mr. Balganorth?
Aye.
Chairman Richard?
Yes. Okay. Mr.
Okay.
Flins.
And you can move on to agenda item 2, which is the public comment now on the document itself.
I'm sorry. Agenda item number 2 is the staff presentation.
Okay. Okay. We have David Freitag. So let me just make it.
Do you want to suggest that we have public comment
Yeah.
first? It seems if we have a staff presentation,
Yes,
we should do that.
yes. But the comments that were received was only on item number 1. Is that right? Yes. Okay.
The comment that yes, I called for any other commentary on item number 1.
Okay.
There was none.
Okay. So now we have David Freitag for a presentation on item number 2.
Okay.
Good morning.
Good morning.
We'll make this interesting this morning. Again, I'm David Freitag. I'm going to provide you with a brief presentation today on the Bay Area to Central Valley Program EIR. The purpose of this presentation is to review the entirety of this Program EIR process and to highlight the key issues that have been raised in the process over the years, and starting in 2005 on to 2012. We have technical resources here today to assist me to answer questions, if you should have any, or if any topics that relate to the partially revised Program EIR come up, we're here to help answer those. The purpose of this Program EIR was from the beginning and is to this day to support the choice of what the document calls a network alternative, or overall route into the Bay Area to Central Valley, as well as individual alignments and station locations that will become part of the statewide high-speed train system. This EIR is called a Program EIR because the authority decided to use a tiered environmental process. This means that the authority has used a more general first tier or Program EIR to examine the impacts at a general level to support its very general decisions about basic routes for the high-speed train system. The board did this in 2005 for the statewide Program EIR and also for the Bay Area to Central Valley Program EIR. The Program EIR decisions involve a commitment for more study, not an approval to build anything. The authority will then use more detailed second tier or project level EIRs to examine impacts in more detail and make specific decisions about detailed alignments that will actually be proposed for construction. So this slide shows the different milestones in what has been quite a lengthy EIR process. To recap a little bit and go way back, the Bay Area to Central Valley Program process started in 2005 with the conclusion of the statewide Program EIR-EIS. The authority in 2005 decided that the Bay Area to Central Valley connection for the high-speed train system merited more focused study and decided to prepare a second Program EIR on this study area. The authority developed the Program EIR from December 2005 to July 2007, circulated a draft for public comment, and issued a final Program EIR-EIS in May 2008. Final decisions occurred in July 2008, and a lawsuit followed. Based on the lawsuit, the authority prepared a revised draft Program EIR that was issued in March 2010, and which it finalized in August of 2010. And again, more lawsuits followed. In November 2011, the court issued rulings that were not finalized until February 2012. The authority moved forward, issued a partially revised draft Program EIR just this past January, and now before you today is the partially revised final Program EIR. And you might remember this slide from the last time, but this is, at the program level, this is the broad study area shown with the hatch mark between the Bay Area and Central Valley. The Program EIR examined multiple alignments, as you can see here. It's a little hard to see, but there are multiple alignments and station location options that we studied, particularly, looking at how the project met the project objective, being close to existing rail and transportation corridors as much as feasible and possible. It's hard to see, but we wanted to revisit the multitude of options studied in the 2008 final Program EIR. This document contained 11 representative network alternatives, piecing all the little pieces together to create network alternatives. 11 of those were for the Altamont Pass, 6 of those network alternatives were for Pacheco Pass, and 4 of them were combined for both passes. We'll get to the issues at each of the stages in just a second. But before we do that, I'd like to focus on the breadth of the public participation and process that has occurred as part of the Program EIR. With each iteration of the Program EIR, the authority has received and responded to many comments. We've had over 1,000 comments on the documents to date, and a number of, commenters. We've had 1,000 commenters and we've had almost 5,500 comments that we've responded to. Let's look back at some of the issues that were raised as part of each step in the process. So some of the key issues raised in 2007 and 2008 included people actively voicing their opinion on the northern mountain crossings, Altamont versus Pacheco. There was strong concern voiced over the biological impacts of both the major routes across the mountain ranges, including Don Edwards National Wildlife Refuge for Altamont and the Grasslands Ecological Area across Pacheco. There was also strong concern voiced over growth effects for the high-speed train system. At the very end of the process, in May 2008 and again in July 2008, the Union Pacific Railroad sent letters to the authority indicating its refusal to allow any of its right-of-way to be used for the high-speed train. So this, what you're looking at here, is one of the key issues of the GEA and Don Edwards National Wildlife Refuge. I'd just like to point out that all of the network alternatives would have significant potential impacts on aquatic and wetland habitats and other sensitive resources. Back in 2007, in December, over at the state capitol, the authority delivered an extensive slide presentation illustrating these two areas. The program EIR analyzed the biological impacts of placing the high-speed train in each sensitive area. This issue was challenged in court and found to be compliant with CEQA. The Altamont network alternatives that would cross the bay at Dunbarton would impact open bay, salt ponds, salt marsh, mudflat, and vernal pool habitats. The network alternatives crossing at this location would result in more than 39 acres potential direct impacts on the bay and other water bodies, and up to 46 acres of potential direct impacts on wetlands. 33.8, almost 34 acres of that would occur directly within the bay area here. A new bay crossing would also require extensive coordination and consultation with Army Corps of Engineers under the Rivers and Harbors Act, U.S. Fish and Wildlife Service, and the California Coastal Commission. Would involve extensive, uncertain, and time-consuming permit processes. The Grasslands Ecological Area, where the Pacheco Pass alternatives would cross through along Henry Miller Road, including a 3.3-mile elevated structure through the GEA area, similar to what this slide is showing. This would result in potential direct impacts on almost 4 acres of water bodies and almost 16 acres of wetlands. 11.5 of those acres of wetlands would be occurring along the Henry Miller Road alignment as shown here. As discussed in the 2008 final program EIR, the high-speed train would have biological impacts in both areas. The Pacheco Pass serving San Francisco via San Jose has fewer impacts on these highly sensitive resources, including wetlands and aquatic resources, and would not require a bay crossing. It's important to recall here that the Army Corps of Engineers and the U.S. EPA worked with the authority in the 2008 final program EIR as part of the Section 404 Clean Water Act compliance, and concluded that the Pacheco Pass network alternative was most likely to contain the eventual least environmentally damaging practicable alternative, or better known as the LEDPA. The analysis of growth-inducing impacts was challenged in court and found to be in compliance with CEQA. High-speed train as a whole would induce a very small amount of growth per the Cambridge systematic study that was prepared, but most of this would occur in areas already anticipated to grow in the northern San Joaquin Valley. At the conclusion of the lawsuit that was filed challenging the 2008 final program EIR, the court found the authority's 2008 final program EIR was adequate in some areas, like the range of alternatives, the biological resource impacts, and the analysis of growth. The court did find there were some CEQA deficiencies in some areas. The 2010 revised program EIR was intended to address those areas. More specifically, the project description along Monterey Highway south of San Jose and analysis of the impacts of moving and shifting the highway on adjacent residences and businesses, on traffic, noise, and vibration, and Union Pacific freight operations. Relationship of the high-speed train to Union Pacific rights-of-way, and whether the need to be adjacent to UPRR rather than within its right-of-way would lead to additional impacts on property and land use. The comments on this revised program EIR were very extensive and raised a multiple of issues. I'll touch on a few. The discussion of the high-speed train alignment Union Pacific Railroad interface was provided and discussed in the 2010 revised program EIR as shown on this map. What this map shows is that you can get from the Central Valley to the Bay Area on both Altamont and Pacheco with relatively little interface with UPRR. However, some areas, such as the alignment to Oakland, shown in red, you can see it to the right there of the green line going up the bay, you would have particular issues with the UPRR within the right-of-way. The issues related to the high-speed train effects on UPRR freight operations were not further challenged. The 2010 revised final program EIR included extensive comments regarding the range of alternatives and responses to those comments. The comments raised many options that have been considered in the EIR already, such as stopping in San Jose. The authority received a large submission with an option called the SETEC proposal, which had several components identical or similar to those that the authority had already studied or had considered and ruled out. The range of alternatives discussion in the 2010 revised final program EIR was again challenged in court and found to be in compliance with CEQA. The subject of the ridership forecast and the ridership model were also a major topic raised in 2010. Ridership forecasts were prepared by Cambridge Systematics between 2005 and 2007. A peer review by the University of California, Berkeley Institute for Transportation Studies in 2010 questioned aspects of the model. The authority invited representatives from both Cambridge and ITS to present to it in July of 2010 at a meeting of the authority board. The board was able to hear from both groups and ask questions. The ridership model was challenged in court as part of the lawsuit on the 2010 revised final program EIR and found to be in compliance with CEQA. At the conclusion of the two lawsuits challenging the 2010 revised final program EIR, the court again found the program EIR was adequate in many areas. These included, among other things, the range of alternatives, the reliance on the ridership model, and the authority's procedures. The court still found some problems. These were in the areas where the court concluded analysis that should be included at the program EIR level was simply not done. These issues identified traffic, noise and vibration, and construction impacts from lane reduction and shifting of Monterey Highway south of San Jose, and traffic, noise, and vibration impacts of the four-track alignment on the peninsula, particularly the potential for loss of parallel streets and the potential for UPRR freight trains to be on the outside tracks of a four-track alignment. The 2012 partially revised final program EIR addressed these issues. The document also addressed new information, particularly the draft 2012 business plan and the revised 2012 business plan. The authority received 56 current submissions with over 400 comments. The key issues in this process are peninsula traffic impacts, concern that the authority has kept a four-track alignment for the peninsula on the one hand, rather than changing the project to be only blended system on the peninsula. Although less of an issue in this round of public comment, there were still a number of comments suggesting the range of alternatives was inadequate. So we'll just walk through these issues now. The peninsula cities that participated in the comment process generally all expressed concerns about traffic congestion from loss of lanes on streets parallel to certain portions of the right-of-way. These included San Mateo, San Carlos, Menlo Park, Atherton, and most prominently Palo Alto. Mitigation strategies were identified to address the traffic impacts. In addition, depending on project level design, refinements such as some of the anticipated lane loss could be avoided. A second key issue in this process was the relationship of the program EIR to the business plan. The draft 2012 business plan was issued in November 2011. The partially revised draft program EIR, which circulated starting in January, addressed the implementation strategy for the high-speed train system in the business plan to the extent it had implications for the analysis in the program EIR. For example, in Chapter 5 of the partially revised draft program EIR in front of you, addressed the phasing concepts in the business plan and described the different environmental consequences associated with the temporary northern high-speed train terminus, a condition which may occur if the high-speed train reached San Jose or Union City and either station served as a temporary endpoint while connecting service for a one-seat ride is implemented. Another example is that in Chapter 5 of the same document, there's a brief discussion of the blended system and what it might mean in terms of different impacts. The analysis of phased implementation, including the blended system, was done at a first-tier programmatic level. But we do want to make it clear that the implementation strategies in the business plan were not ignored. They were discussed and addressed as appropriate at the programmatic level of detail in the partially revised program EIR. Finally, some comments suggested that the program EIR needed further revision and recirculation to study additional alternatives. The focus this time was on the suggestions that 1, blended for the peninsula should be treated as a separate alternative, and 2, the authority should study in detail an Altamont Corridor rail project alignment with the blended system on the peninsula tacked on, shown in the dotted red line there. As part of responding to comments, staff and consultants looked at these options and provided responses in the partially revised final program EIR. The blended system is not considered a separate alternative. The blended system is a component of phased implementation for the second-tier project on the peninsula. It requires a separate second-tier planning process to develop it in more detail to analyze impacts at a level of greater detail than what was provided at the program EIR stage. The other proposal shown here is not a reasonable alternative because the facts available show it cannot meet the project purpose and need and project objectives. It is based on a slower, more circuitous alignment for the Altamont Corridor rail project. Travel times to San Francisco from LA are anticipated to be far longer than the preferred alternative, in excess of 3 hours and 17 minutes due to slower speeds and longer distance. In addition, although this alternative may avoid some impacts from the preferred alternative, it is not itself environmentally benign. There would be environmental impacts associated with this alternative as well. For these reasons, in the judgment of staff, the authority need not stop its process, study this additional idea, and circulate the idea for public comment. In short, the conclusion of staff and the consulting team is that even with new information, the range of alternatives studied in the program EIR remains reasonable and complies with CEQA. There are a few points I'd like to close with. There will be adverse impacts to the natural environment and the human environment from the high-speed train, no matter where you put it. There are also many, many benefits to be derived from the project. The decision before you, assuming you certify the program EIR, is to balance the different types and degrees of impacts in different locations with the project benefits and the ability of the different alternatives to meet the project objectives. The program EIR as a whole looked at 21 network alternatives. So Altamont runs across the top and Pacheco alignment alternatives run across the bottom there. We studied 11 Altamont Pass network alternatives shown here in blue on both of these slides. We studied 6 Pacheco Pass network alternatives shown here in blue on each one of these, and 4 combined Pacheco and Altamont Pass network alternatives. The range has been challenged twice and upheld twice, and the team feels strongly that this range of alternatives continues to be an adequate and appropriate range for the board's decision making. Finally, the program EIR sets forth the rationale for the staff recommendation that continues to be the Pacheco Pass network alternative serving San Francisco via San Jose. Why? Because it best meets the purpose and need for the proposed HST system. It minimizes impacts on wetlands, water bodies, and the environment, best serves the connection between Northern and Southern California, best utilizes an existing publicly owned rail corridor with potential for track sharing, still supported by the Bay Area region, and the Corps and the EPA have concurred that the preferred Pacheco Pass network alternative would most likely yield the LEDPA. This rationale is set forth in more detail in Chapter 6 of your revised final program EIR binder. So with that, as you move forward today in your agenda items, we note that the partially revised final program EIR not only includes the 2012 document and response to comments, but also the 2010 revised final program EIR and the 2008 final program EIR. For 2012, we also prepared a 6-page addendum that you have in front of you about project benefits in light of the revised business plan and additional technical piece of information. This is also out front for the public. Let me just point out which the documents are that you're looking at here on the table. The taller stack is the 2008 final program EIR. The middle stack is the 2010 revised program EIR. And the one to the far right is the 2012 partially revised program EIR. That is the whole of the record in front of you. The partially revised the partially revised final program EIR was issued on April 6th. Documents were made available on the authority website. They were distributed to over 930 federal, state, local agencies, tribes, elected officials, and other groups and individuals who commented on the 2007 documents, 2010, and 2012. These documents are also in 16 libraries across the study area. A notice of availability and consideration was distributed to a mailing list of over 24,000 individuals, and the notice was also published in 11 newspapers. All of the information discussed in this presentation is part of the entire record before you and is considered part of the partially revised final program EIR. This 6-volume of documents is provided to you for your decision-making process. In conclusion, staff recommends that the board certify the partially revised final program EIR for compliance with CEQA and proceed to making new decisions after public comment. And now we'd like to open it up for questions.
First of all, Mr. Freitag, I want to thank you very much for a very comprehensive, very clear presentation. Even though I've been reading through these materials, even just the titles of the various documents and so forth get to be a bit of a blur. So as a newer member of the authority, I very much appreciated that very lucid presentation. Let me now ask for public comment on both the staff report that was presented and also the pending action before the board to adopt the final. To adopt the partially revised final program EIR. I'm going to get that. I'm going to trip over that all day. As I said, I've withdrawn those speaker cards that identify that they're for items 3 and 4. We'll take those together. I'm calling people in the order they are received. I do not see at this point any elected officials whom we would ask to go first. I'm sorry. And we'll set the time at 2 minutes for these. 2, 3, 4, 5, 6, 7. Why don't we set the time at 2 minutes for the public comments? So first is Stuart Flashman. And Mr. Flashman will be followed by Kathy Hamilton and then Dan Ursig.
Good morning again, Chair Richard and board members. And again, my name is Stuart Flashman, and I represent the plaintiffs in both Atherton 1 and Atherton 2 lawsuits. And it was pointed out to me today that I've now been working on this issue for 10 years, which I think is probably longer. I'm pretty sure it's longer than any of you board members have been on the board, and I think it's probably longer than most of the staff has been involved in this.
I think Ms. Shank might have been here.
I want to say that we appreciate, again, as I said last week, we appreciate some of the changes that the authority has made in the last year. However, we do not think that this EIR is ready for prime time. And this is the third time I'm standing here in front of this board and telling you you have an EIR that you should not be certifying. And twice before, I've said this, and you've gone ahead on recommendation of staff and certified an EIR, approved the project, been brought into court, and the court has said, nope, you were wrong. And I'm presuming that you are thinking at this point, well, third time's the charm. But there is another third phrase that might apply here, and that's 3 strikes. And we know the consequences of that. And I would hope that you're not going to go ahead in that direction, because it would be a shame if the result of your moving forward here would be that eventually the high-speed rail system didn't happen. Because most of my clients actually would like to see a high-speed rail system, but they would like to see it done right. And frankly, this project, EIR, doesn't do it right. The major issue, I think probably the biggest single issue, is the refusal to study the blended alternatives. It's a true alternative, which it is. And Chair Richard, yesterday at the legislative hearings, acknowledged that this will meet the criteria that need to be met, and yet you're not considering it. That's wrong. Thank you.
Thank you, Mr. Flashman. Kathy Hamilton, followed by Dan Ursig, followed by Jim Bigelow.
Hi, this is Kathy Hamilton, Community
Good morning, Ms.
Coalition.
Hamilton.
Hello, how are you? That took
thanks.
2 minutes. Anyway, I just wanted to make a couple of notes on this particular alignment. Union Pacific does not own the right-of-way, but they retain vestige rights, and they get to make decisions on who is on the tracks as far as intercity rail. This opinion is lacking and very important for you to move forward, and I understand that we are more than a year behind in obtaining permission, and that for that alone you shouldn't certify, you should get that first. The other thing I wanted to say, while the blended system does hold some promise if it is done right, it does not follow what Senator Simidian, Anna Eshoo, and Rich Gordon promoted. Still in this EIR is an elevated track option and a 4-track option. And most importantly, we haven't gotten the opinion from the Attorney General that the blended system complies with 1A and 3034, and there are several problems with that. So what is happening, let me just borrow something from Senator Simidian. He said, if you do not reduce the scope, you will leave a sword hanging over the head of all of the residents and businesses along a 50-mile crowded corridor. So please do not certify. I'm sorry, we don't trust you this time to go ahead with the blended. Thanks.
Thank you, Ms. Hamilton. Dan Ursig, followed by Jim Bigelow, followed by Catherine Phillips. I'm sorry, Ms. Hamilton, did you need something? It is. Morning, Mr. Ursig.
Good morning. My name is Dan Ursig. I've been active in neighborhood preservation and restoration for 27 years in the city of San Jose. I'm here representing a neighborhood association called the Greater Gardner Neighborhood Coalition, which represents 3 of the oldest, most historic neighborhoods in San Jose, just south of the Diridon train station. This might sound a little strange because I don't think you have many people complimenting you, and usually I'm not complimenting you either. But in this instance, our coalition would like to take this opportunity to do that. I'm here to comment on Agenda Item 4, specifically the 280-87 bypass. Much time was spent with your staff and our neighborhood to find a solution for both our neighborhood and HSR. We would like to thank you, your staff and the board, for keeping this bypass in the revised EIR. Also, we'd like to give an extra thanks to Gary Kinnerly for his patience and clear thinking on this matter. I think I'm almost out of time. We look forward to working with you in the future, and we really hope that we can all take the time to make high-speed rail what it really needs to be. Thank you for your time.
Thank you. I was going to say we are tempted to extend time for people who are thanking us, right? But we don't do that.
I don't have any other good things to say.
Okay.
Jim Bigelow with the Redwood City San Mateo County Chamber. The revised partial document appears to be much improved, and in spirit of the court order, hopefully it will meet the test. The discussions relative to Altamont Pass and the Dumbarton Corridor, those have gone on for years and years, and I would note there's a $19 million EIR, EIS plan that's going to come out in the next couple of months for the Dumbarton Rail Corridor, which is in the photo shown by staff in the staff report. And we would take exception to seeing that track right on the Dumbarton Rail the way it's portrayed, because that's a needed other connection. We have supported Pacheco Pass for a long time after looking at the merits of both Altamont and Pacheco. And I think there's been a lot of work done. I've attended a lot of meetings relative to the Monterey Highway south of San Jose and the work that's been done. So there are detailed project-level work that's underway, and it's really going to identify the detail, which is the level below the program document you're considering today. I would hope that we could move forward with the recertification and move on and start looking at the results of the project-level work and the blended system. The blended system is very, very important on the San Francisco Peninsula. Some cities don't like the 4-track, and that in itself could contribute to some litigation in this document. But you know best, I hope. Thank you.
Thank you, Mr. Bigelow. I have to say that I suspect you're in the minority of people who think we know best, but we appreciate your comments very much. Catherine Phillips, followed by David Schunbrunn, followed by Richard Tolmack. Good morning, Ms. Phillips.
Good morning. I'm Catherine Phillips with Sierra Club, California. First, I'd like to thank Chairman Richard and the rest of the board members for the attitude and openness that we've seen. We think it's a shift from previous authority approaches, and we really do appreciate that in the last few months. There's been a lot of reaching out. We've had a lot of effective conversations. I'm here today, though, to ask the board to take appropriate action to ultimately shift the train's east-west route between the San Joaquin Valley and the Bay Area from the Pacheco Pass to the Altamont Pass. A shift in the routing would avoid directly impacting California's largest inland contiguous wetland, an area heavily used by birds and other wildlife. It would avoid inducing sprawl in an area that's mostly rural or otherwise less developed than the Altamont Pass route, and it would drive the train through a highly populated but underserved transportation corridor by going through the Altamont Pass, and it would complement existing and anticipated growth and transportation improvements in the Altamont Pass, the North San Joaquin Valley, and the Southern Sacramento Valley and areas west of the pass. And shifting the route just makes better sense for the environment and for a good transportation system, and frankly, I think it'll make this thing move faster. And I mean this by the process, not necessarily the train. So I urge you to encourage your board to go back and study the Altamont Pass blended approach that they haven't studied yet, and consider that as a way of getting this train moving. Thank you very much.
Ms. Phillips, may I ask you a question?
Yes.
Since you represent perhaps the most prominent environmental organization, as a decision maker, I just heard the staff indicate that we're going to have environmental impacts on sensitive wetlands no matter which way we go. The Don Edwards National Wildlife Refuge from the Altamont approach versus the grasslands from the Pacheco. Do you have thoughts on that to help guide?
Yeah, I mean, that assumes that the only approach once you get over to the Bay Area is to build a new bridge or expand a bridge for the train across, use the Dumbarton Bridge approach. But my understanding is that there are alternatives, that if you use some kind of blended approach where you took the train down to San Jose and then proceeded using alternative methods, that you could still have a very fast train, you could get people moving, you'd improve the Bay Area transportation system, and you'd avoid what is, frankly, a very, very sensitive wildlands area. And if I may just share sort of a personal anecdote, I rode with actually a number of different people, including a couple of legislators, a train from Madrid to Toledo, a high-speed rail train. It was very comfortable, a very nice ride, but we had, because the legislators were there, not because I was there, we had the opportunity to go up and actually be in the little area where they were driving, so we saw the front view. And ironically, as we're going up there, a beautiful bird of prey was smashed by the windshield by the train. And, the interior wetland area, the grasslands ecological area, is on the edge of or right in the Pacific Flyway. So I can imagine that going forward in the future, you might anticipate, even if you put it higher up, you're still going to have some bird-train conflicts. And you may have a density of bird-train conflicts there that could cause problems, just as we've seen problems with bird-windmill conflicts on the Altamont Pass. So I would encourage you to consider an alternative approach, one that doesn't necessarily go across the Dumbarton Bridge, but uses a more blended system.
Okay, thank you. Thank you very much. Mr. David Schunbrunn, followed by Richard Tolmack.
Recognizing the biological impacts that we just heard about for both Pacheco and Altamont alternatives, my organization and its colleagues submitted a new alternative comprised of the Altamont Corridor Rail Project, which has already been deemed feasible, and that optimized for speed, coupled with the blended approach going from San Jose to San Francisco. This alternative would avoid all the major environmental impacts identified in previous EIRs. The FEIR refused to study this alternative, contrary to the mandate of CEQA. I sent you a letter this morning. It went to each of you, and a letter has been handed in physically here today. You, as project sponsor, are not entitled to say the full build is our project, the blended system is a mere implementation strategy. When an environmentally superior alternative is proposed, you have to study it and then adopt it. If you insist on certifying this document, you will be back in court and lose. There is a very clear subtext to the response to comments. It says to us, we've already made up our minds where the tracks go. Please don't keep bothering us with rational arguments because we will never, ever agree with you. Even when you have strong arguments, we will make stuff up if we have to. PB claimed we said things that we never said, just so that they could knock them down. It's despicable and unprofessional, and it's contrary, and it's also wrong on CEQA. You're a new board. You are not responsible for the decisions of the past. Have you learned anything from this organization's two previous expensive and time-consuming losses? Please don't follow your consultants into yet another morass. You are tasked by the governor with setting a new tone for this agency. Please do so by demonstrating leadership and walking back from the brink. Please send this EIR back for revisions consistent with CEQA.
Thank you, Mr. Schunbrunn. Mr. Tolmack.
Rich Tolmack, California Rail Foundation. Thank you, Chair and members. I want to focus on the great advantages that there are to going through the Altamont Pass versus Pacheco. From a Sacramento perspective, from a Stockton perspective, from a Modesto perspective, Pacheco is an atrocity. Trying to go from Sacramento to the Bay Area through Chowchilla is something that no rational person would do in a car. It's also crazy to take a train that route. It's nearly 300 miles, and it wastes energy. That is part of the ridership your Pacheco alternative is based on, is the supposition that there's going to be a great number of people going from Sacramento, Stockton, to the Bay Area via a crazy route. And it's something you need to address this time around. You need to get actual verifiable figures that Caltrans and other transportation agencies could actually buy into. What you're basing this bad EIR on is a set of already discredited ridership figures. You need to get a fresh look. And that's why in these two prior times you've come up with a silly result instead of something that the community could buy into. This is why you're having so much problem getting through any place. It's because so far you guys haven't listened. This time you should listen to the public and you should look carefully at the ridership claims. Thank you.
Thank you, Mr. Tolmack. I just want to make sure that anybody else who provided a speaker card in the past, it didn't look like any of them were on these items, in case I missed that. Okay, seeing no indications to the contrary. Mr. Filens?
Thank you, Chairman Richard. So we're moving on to item number 4 now on the agenda, and it provides the board an opportunity to consider taking action on the draft resolution in your board book. That's numbered 12-17. And this resolution, if adopted by the board, would do a number of things, and I just want to take a few minutes to kind of walk you through and make it clear what you'll be voting on if you adopt this. First, the resolution 1217 would certify the partially revised final program EIR as being in compliance with CEQA. In taking these steps, the board would be making 3 certifications. First, that the program EIR has been completed in compliance with CEQA. Secondly, that the program EIR has been presented to the board, that the board has reviewed and considered the information in it prior to taking any action to approve the project. And 3, that the program EIR reflects that the authority's independent judgment has been rendered. So I'd like to emphasize these 3 certifications. On the first one, it's the opinion of staff that with the partially revised final program EIR, all issues identified by the court in the CEQA litigation has been appropriately addressed. On the second, I'd like to remind the board members and make clear to the public that the staff has provided the entire program EIR to the board, including the 2008 amendments, the 2010 documents, and the 2012 documents. And on the third certification, I'd like to emphasize again that the board must certify the EIR reflects its independent judgment. And what this means is that the board is taking a fresh look now at all the program EIR materials, all the items generated from 2005 to the present, and that the board must in good faith take this all in, exercise its own judgment, not just a rubber stamp of the recommendations of staff. And what we call this is taking a fresh look, but it's not a blank slate, because you also need to consider the whole of the record before you made this decision. The second thing that you'll be doing today is the resolution would approve what are called CEQA findings of fact, and that's been presented in the materials that you have received and have read. These findings are attached to your resolution as Attachment A. These are required by law and essentially recount that the authority has adopted all feasible mitigation strategies at this program level to avoid, reduce, or mitigate for impacts. The third thing that the resolution addresses, and what you'll be voting on if you adopt this resolution, is that it would approve what's called a statement of overriding considerations. This document sets forth the agency's balancing of the environmental impacts of the project that cannot with certainty be fully mitigated against the economic, legal, social, technological, and environmental benefits of the project. I'd like to note that the revised statement of overriding considerations has been provided to you and in a red strikeout format with more clear references to the benefits of high-speed rail as identified in the business plan. And this item is also made available to the public this morning, as it was you this morning, with other board materials, and so you can see these few changes that were made. The fourth thing that this resolution would ask you to do would be to adopt a mitigation monitoring and reporting program, which is required by CEQA. And this document is attached as Exhibit B in your materials. The fifth point that you would be considering in adopting this resolution would be to approve the Pacheco Pass network alternative serving the San Francisco via San Jose, as discussed in the staff presentation and as recommended in the program EIR document itself. So this step is an approval of the programmatic project. I just want to make clear here that it's just that this step, what this step does or doesn't do. The approval of the programmatic project is essential, is in essence an approval to advance this particular route for more environmental analysis. It's not an approval to build anything. It's a programmatic level document. Finally, the resolution includes language under next steps, that would direct staff in how to proceed. And on this language, I want to call your attention to the last paragraph. What this particular paragraph would do is to direct staff to work with Caltrain and local governments to develop a description of a blended system project for the peninsula. And then the language directs staff to focus the second tier EIR on that blended system approach. And this language has been included because staff believes it's consistent with the business plan that was just released, and it's consistent with the program EIR that's before you. With that, I take the opportunity to answer any questions. And at this time, you should deliberate on this issue and consider decision.
Thank you, Mr. Filens. Mr. Hartnett.
Thank you, Mr. Chair. I do have a number of questions. First, just a general comment. I appreciate all the hard work that's been put into the revised documents. In my prior capacities, I've had the opportunity to review a number of very substantial environmental impact reports, and I find this to be a very comprehensive treatment of the required subject areas. So I appreciate the work that's been done. But I still have some questions. And, Mr. Sheriff, my experience with these in the past in other forums is sometimes it appears that I'm hogging the questions. And so I don't intend to do that, but I do have a number, and if at a certain point you want to cut me off, please, I won't be embarrassed if you do that, but I do have a number of questions.
Mr. Hartnett, we have the room till 1:30. I'm not going to cut you off.
Yeah, but I've had a couple bottles of water already, so I can't last that.
I may beat you to it this one. It might be me. So.
First, just in Mr. Filens, and I know you may defer some of these questions to others. The fact that there's been an appeal filed of the decision, the court decisions, that I just want to be clear, that does not mean that we can't proceed if we choose to today to recertify this revised.
That's correct. You can still take this action today.
Okay.
The appeal was filed on the 13th of April, last Friday, and it stays the Superior Court rulings. But you can move ahead with this action today.
Okay. There's also a question raised with respect to the business plan having been recently adopted, and it refers to the blended approach. I want to be careful on this. We're not precluded from proceeding now as this document is drafted based upon the recent adoption of the business plan, which does make reference to the blended approach, are we?
No. The business plan is not an environmental document. It's separate and distinct from that. And the fact that the business plan was adopted does not preclude you from moving ahead with this document. In fact, the business plan and this programmatic environmental document is consistent with each other. They both talk about phasing, and they both talk about and analyze blending, the blended system. So there are no problems with that.
Okay. And I note with the resolutions that are included is the direction that if we proceed, that at the project level, in the second tier EIR, that the direction be to study that. I know there's been continuing work by Caltrain, and also we had suspended work with respect to the overall project EIR because of both the litigation and the ongoing work relative to the blended approach, as I recall.
That's correct.
Yeah.
The board did ask that the environmental document at the project level between San Jose and San Francisco stop, a timeout to look at the programmatic level document that had to have some changes made, and also to consider this blended concept that had been proposed by some local elected officials and state legislators.
Okay. And while we're talking about the blended system, can you comment on how, in comparing the ultimate alternatives versus Pacheco, how do we tell at this stage, or do we need to tell whether the blended approach works best with one or the other?
The programmatic EIR looks at the impacts of blended, and you can consider that in the context of either route.
Okay. So I think, is there some additional comment on that?
Sure. So for the blended system, would it be better with Altamont or Pacheco?
Yes, or how do we, are we making that determination now, or how does that fit in?
Well, the Pacheco corridor would use the blended system. You would still have benefits from the high-speed train system, but you would still have, you may not have the same level of benefits with any of the alternatives using the blended system from San Francisco to San Jose. You could have improved benefits related to air quality, but not at the same level as what you would have with the full system. The same with energy. Traffic impacts may differ because you're not getting all of the great separations in that you would with the full system. Dominic, you want to add some more here?
Yes. My name is Dominic Spathling with the program management team. From an operational standpoint, we really looked at whether it would make much difference if you came the Altamont corridor or the Pacheco corridor and could tie in with a blended system on the peninsula. And we found that you could. You're able to do that on either of the alignments.
Okay. All right. And I've read the materials that refer to that in the revised plan as well. I have actually more. Maybe this is more of a legal question. You could interpret the court rulings in a kind of an oversimplified way to say that the court found in both the Atherton lawsuits that there were problems with the level of detail in the program ER. But to me, that's kind of I mean, people may say that, but it's kind of an oversimplified view of it because as I understand it, there's a level of detail in any program ER, but the the specific details are subject to the second tier analysis, which is the project level EAR. And so I just want to, just talk about the impressions, really, in a sense of the court rulings in that regard. Is that really an oversimplified statement?
The level of details were adequate in the programmatically EIR. It's just it was the descriptions of the project description was not complete enough, and so we've addressed that more thoroughly in the revised document. And when we talk about the details, the project level details will come out in the next tiered document, the project level document. So both documents are quite different. The staff believes that the details were adequate for the programmatic level document. Initially, the court just wanted a better project description.
Okay. Maybe more of a non-legal thing. On the environmental considerations of Pacheco versus Altamont, there's obviously a lot of the materials in connection with that, and there are many factors that go into the choice of one alternative over the other. Environmental is obviously a very important one, and there seems to be some conflicting views on what's the best environmentally wise. But can you comment about the comparison of the impacts on the Don Edwards National Wildlife Refuge versus the grassland ecological area in the two alternatives?
Sure. If you remember in the presentation, the photos that we showed there crossing, on the presentation where we showed crossing Don Edwards and versus GEA, both alignments would have impacts. You're not going to get away from impacts. But for Pacheco, you had 15.6 acres of wetlands crossing on the network alternative that would cross the GEA. But within the GEA itself, you had about 11.5 acres of wetlands. So and then compared to Dumbarton crossing, where you had 33 acres of wetlands just within that bay area. It's definitely more than half less than the impacts. You'd still have impacts on sensitive species. That's pretty much a wash related to plants and wildlife, pretty much equal on both of those. So, and then on the other portion for the GEA crossing, we're looking at approximately 3-mile elevated structure along there to allow wildlife movement and less impact on water resources.
Mr. Hartnett?
Yes, sure.
I had a question on that same subject. So would you just, before you move on to a different subject area, let me...
Absolutely. Go ahead.
Is that right now? Okay. Thank you. This is the thing that I think has been the biggest struggle for me in looking at this. And you heard my question for Ms. Phillips of the Sierra Club. And I understood what she was saying about the grasslands area being on the flyway, which means that there's the possibility of, or perhaps we even would say that, some likelihood of some interaction between the trains and wildlife there. In looking at these, I don't pretend to know the details about the Don Edwards Wildlife Refuge, but I presume it also would we be looking at similar types of impacts
Sure.
moving through those?
Yeah, the potential for bird strikes happens anywhere. For areas going across to the GEA, there is the potential for additional bird strikes, but you also have that potential within the Bay Area where you've got, lots of waterfowl located in that location.
Now, the other question on that was, I don't want to get this wrong, but I thought I understood from Ms. Phillips that she was suggesting that there were other pathways, if you will, that would avoid either of those sensitive wildlife areas. I'm guessing that would mean coming down something along the UP alignment down towards San Jose and back up or something like that. Do you have any sense of what that would be?
Yeah, we studied one of the network alternatives that we had on multiple maps there. We had it coming across Altamont, coming across the Diablo Range, and then down to San Jose, and then back up the peninsula. You want to speak to that at all?
Can you comment a little bit on the issues with that particular one? Or? Yeah.
I wish I had a photographic memory from everything in there.
Let the record show that Mr. Freitag was pointing to about a 4-foot stack of documents and said that my answer would be in there somewhere. So,
if you look in Chapter 7 and Chapter 6 of the document where we talk about we go through the recommendation of the preferred alternative, we talk about the different network alternatives and how they stack up to the recommended. And I believe, we had slower travel times being probably one of the main things.
Yeah, that was, as I'm struggling with this, that was the impression I got, was that we would be challenged on the travel time to meet the Prop 1A requirements.
If I'll elaborate a little more on that, one of the interesting aspects of it is the way that we would come into San Jose would be similar to how the BART station currently is configured at SFO Airport, where you'd have to go in and then reverse direction and then go back up the corridor. And that, at least in this document, we assume that would take 20 minutes in itself to reverse the direction of the train, and that's what the record states. So that, along with the sort of semi-circuitous route of coming down to the end of the bay and then proceeding back north up to San Francisco, has pretty significant effects on travel time and most likely on ridership too. And that's also as part of the Chapter 7, Chapter 6.
And I just want to thank you, since I was involved in that BART to SFO design and alignment, for pointing out that it's very kludgy. So that's... No, just... All right. Mr. Hartnett.
I have some more on that same subject here, but I noticed Mr. Balganorth.
Mr. Balganorth?
I was just curious if we could ask Catherine Phillips again about how close a call was that for, in your mind, between the Altamont and the Pacheco? Because it sounds like people are saying that there's less environmental damage. Some people are saying there's less environmental damage in Pacheco Pass. You're saying it's the other way. How close a call was that for each side?
I think you have to look at it in total, in the whole of the whole network alternative going Altamont versus Pacheco. Altamont, you have a lot more people living along the corridors as opposed to animals and plants along the Pacheco alignment and farmland. So you have a trade-off of what the impacts are. It's not, there's not one particular item that puts it over another. It's, looking at the total of the environmental impacts.
Could I hear what Catherine had to think about that as well?
Thank you. The thing about Altamont, when you mention a lot of people, that means you have a lot of potential riders. The thing about Pacheco is you do have these wildland areas, but you don't have a lot of potential riders. But what you do have is the potential for inducing sprawl into those areas. So you could indirectly, by putting the train through that pass, also create greater harm to that wetland and those birds than you would by putting it in another place. It's not just the bird kills and bird strikes, which it sounds like it's kind of a wash. It also is the sprawl inducement, which then has a multiplier effect on the wildlands areas. And just from a transportation point of view, sort of just makes more sense to put the train where the people are, and especially in this case, you'd be able to take greater advantage of it from the Sacramento area and from the northern San Joaquin Valley area.
What about the 10,000 acres that's getting that we're going to put in the
Bay Area?
Right.
Well, to be quite frank, it would be our preference not to put it through any wetland, and that's why my understanding is there hasn't been a full analysis of this other blended approach. And while there would be slower speed times, what I have been hearing is that's because the sort of quick and dirty analysis, not the deep analysis, has been, well, you can't straighten out the route and you can't make it you can't make it as fast as you should be able to. I should emphasize that we support the notion of high-speed rail, and the idea of doing blended, what we're really concerned about is to make sure that we have something that is connected and works from the get-go, and something that actually gets done. And my big concern, in addition to the environmental impacts, is that if we continue to have this Pacheco versus Altamont problem, we won't get to a point where we'll have something on the ground. And doing this alternative where you would go to where the people are and potentially avoid two, or at least analyzing it deeply, and avoid two, potential bird impacts or wetlands impacts, makes a lot of sense. I think this board, from my impression, is certainly has been more open to this kind of conversation than we've seen in the past, and I do thank you for that, and thank you for listening to my views on this.
I want to, yes, go ahead, Mr. President.
I just wanted to comment on something. The sprawl doesn't occur because there's an alignment there. The sprawl occurs because of stations. The station location and placement is a determinant of where growth is likely to occur. So in Prop 1A, there's language in there that says there's no station between Merced and Gilroy. Specifically, there's no station or maintenance facility in Los Banos. So the potential for growth, nobody wants to just move out and live next to a rail line, is probably much less potential than around stations in an urban area.
Yeah. Can I clarify something?
Mr. Hartnett.
Yes, I think, and when this might have been lost as Mr. Baglinoff was making his comment, there's a authority obligation with respect to 10,000 acres of preserving 10,000 acres in the grasslands area, and so I think that relates to this discussion as well. So I think.
I might not have been very articulate in my question, but that is my question.
Yeah, and so that comes into play as well in terms of the choice. And Mr. Chair, I think there's a difference in terms of the legal status of some of the protected areas as well.
Yes.
Maybe you can comment on that, because that also comes into the equation.
Mm-hmm. So the National Wildlife Refuge for Don Edwards was formed by an act of Congress in, I believe, 1972. So it's protected. So any changes or anything within it has to be approved by the Department of the Interior, the Secretary of the Department of the Interior. The GEA is, there's a long description of it in there, but let me just give you kind of a short answer. It's a non-jurisdictional, non-regulatory, generally designated area used by the Fish and Wildlife to identify an area for priority purchase, public easements for wetlands, preservation, and enhancement. And then within the GEA, to the north part of it, it's a large area, but within the north part of it area, there's the San Luis National Wildlife Refuge, far away from this alignment.
Mr. Hartnett, if I might, I'd like to just exercise one prerogative of the chair, just out of what I think is a sense of fairness. Ms. Phillips is a recognized environmental expert, and we appreciate her answering questions, but it resulted in her getting some additional time here. And I think what I would ask is I'd ask those speakers to just be fair with us on this specific question that we asked Ms. Phillips, which related to the specific issue of the relative impacts between the Don Edwards wildlife area and the grasslands wildlife area as it pertains to our decision between Altamont and Pacheco. I would offer to any of the prior speakers who cared to comment on that the opportunity to do so, just so that we have a fair opportunity for all people to have an equal opportunity to address the board.
David Schoenbrunn, I appreciate very much. Because I had wanted to add a point to what Ms. Phillips had to say, and that is, in the 2010 litigation, we filed a biological opinion that said that the analysis done at the program level had been inadequate because it did not look at comparing species. it was so broad brush in terms of acres of wetland that it did not get to the issue of biological sensitivity. And so you have no evidence in the record at this time as to which of those wetlands areas is more biologically sensitive and more biologically valuable. And in the absence of that information, we've argued consistently that you can't make a decision. Thank you.
Thank you, Mr. Schoenbrunn. Mr. Bigelow, then Mr. Flashman.
On the Dumbarton Rail Corridor, it's a refurbishment of a regional commuter rail service, and it falls in a separate category with respect to a rehabilitation of a corridor going through the Don Edwards Wildlife Area. And the EIR, EIS that's gone on, the biologists and everything involved in that refurbishment to do a regional rail project have been working out the sensitivities and the mitigations on tidal actions and flows that were changed by the berm back in the early 1900s. So if you were to put in a new rail, a new shadow, because only one track goes across the part of that, then it changes the whole project with BCDC, and you end up in years and years of additional permit questions and so forth. So it would take years for high-speed rail if it were to try and go across over the water to go through the process. And we've been at it a number of years with the EIR, EIS already. So it's not simple.
Okay, thank you, Mr. Bigelow. Counselor, Mr. Flashman.
Thank you. And I'm not going to speak primarily as an attorney. I'm going to speak as someone who used to be a biologist before I became an attorney.
I think that's allowed.
Okay. But I think there are a couple of things that I think are very worth thinking about here. One is that, you do have the court litigation, and the court litigation basically said, yeah, you've got enough substantial evidence to support your decision on biological issues on Pacheco versus Altamont. Now, that's a legal standpoint. I don't know that necessarily just the fact that you've got some substantial evidence to support you means that's the best choice. That's a legally defensible choice, but it's not necessarily the best choice or the right choice. And I think that's a separate issue that you need to have in front of you, is thinking about what's the best thing to do here, not just what's legally permissible. The other point I want to make, and a couple of points. One is on Dumbarton and using the Dumbarton Rail Bridge as it's being proposed to be refurbished. That would fit with a blended approach. That is to say, what the EIRs have looked at is saying, let's do a high-speed rail bridge. Let's do a bridge that would be what we'd like to do, is a full steam ahead high-speed rail going across the bay at, at least 110 and maybe 220 miles an hour. But if you did it using not using the type of equipment that the Caltrain would use in terms of using diesel locomotives, but if you did it using high-speed rail equipment the same way it would be going down the peninsula on the blended approach, then what's being done in refurbishing, the only thing you'd need to change would be to add the electrification. Okay. And then you could use it for both. It wouldn't be ideal, but it could work, and it might be faster than going around.
Okay.
And so that's another point. And again, the other point is that you do have an alternative that wasn't studied that would look at going around. And there's another alternative that hasn't really even been touched, which is the idea of going across parallel to 237, which doesn't get you all the way down San Jose, but does get you across without going across the wetlands and across the bay.
Thank you. Mr. Tolmack, on this narrow question?
Yeah. But as he's come up, I think Mr. Flashman proved the point that attorneys are human too. So I like that.
The record will so show.
But it was attorneys that said that.
Right. You're right. That may.
Thank you. I wanted to throw in one other factor on the Don Edwards Reserve, that the group that has sponsored and protected the refuge there is fully in favor of using it for rail. and for high-speed rail, and they've been a supporter on our side. So I feel that this debate about that somehow going across there with a train at a reasonable speed is somehow environmentally damaging when you already have a highway right next to this. And your contact, you can improve the tidal flows by this rebuilding job that they're doing. You can open up sections that are currently blocked off and therefore don't have full adequacy for the wildlife that's using it, and improve the thing. And that's what we were originally proposing, is that mitigation be done which actually improves the area and the refuge and improves it as a habitat. And the other thing I wanted to get to was that the specific timings involved in a reverse of direction on a high-speed train. In Germany, they seem to be able to do it in Frankfurt in 5 minutes. I don't see why in California we would take 20.
Thank you, Mr. Tolmack. Mr. Hartnett, thank you. I just felt it was important to make sure we had a fair opportunity for all our citizens to speak before the board.
Thank you. I agree with that. Just on that subject of the environmental considerations, I have a question on the Henry Coast State Park, because that was, I know, a substantial point of discussion as this proceeded. How is that now affected by the Pacheco alternative?
It's not. The alignment is further south in the Henry Coast State Park. You have 152 as a buffer as well. And, at the project level, as they move into additional studies, there may be different elevation profiles, whether it's elevated or in a tunnel, being looked at.
So I just recall that it's been a big point of discussion. And what about any state wildlife areas?
Okay. Pardon me?
Are there any in the Pacheco alternative, the impact on state wildlife areas?
Not within the GEA. We're south of the Los Banos wildlife area. We're definitely well south of the San Luis National Wildlife Refuge along Henry Miller Road.
Okay. I've got some questions that are, these have been generally out of Chapter 6, which is in the plan.
Chapter.
I have other more specific questions as well, but I want to ask about the ridership, the conclusions of the staff in terms of the ridership forecast. I take it that the ridership forecasts are not in and of themselves determinative of the selection of Altamont versus Pacheco. Is that a fair? Looking at the broader picture, so you're not. It's a factor. Environmental is a factor, but the forecasts themselves aren't determinative. Is that a fair statement?
I would say it's part of the overall package of everything that we're looking at.
Okay. As I look at part of our task as we're going through the environmental documents, I'm struck by the reference to people or cities or organizations that support one thing over another, and how that's a factor. And I look at that as people make their comments that they're important for us to know what people are thinking. It helps us hone in on important issues, but it's not. We're not on a board saying, well, how many people or organizations are on this side and how many are on that side. And that's not how we're supposed to look at this. We should be informed by and educated by the comments, but it's not raw numbers. So sometimes in the report it almost suggests that, well, gee, this many people say this and this many people say that, to me that's not the proper balance, and I don't think the report's intending to be that way. Secondly, when we hear people and organizations' opinions, I think we want to hear all the opinions, but the opinions are not necessarily based upon factual data. Their gut feelings, their political philosophy, there are all sorts of different rationales for opinions. And so I think, to me, our job is to really step back and independently look at the record and the data. And that's our role, not to count the numbers, but to really look at the data and be comfortable that it's accurate, and that when we're striking a balance, it's not just based upon who wants what, but what are the appropriate considerations to go into the balance. And so I make that as a general comment because I think it's important. It's so important for us to hear people's opinions, as I say, because it helps us focus. But I think we have to make sure that we're doing our fiduciary role as we look at the record. And that reminds me on some of the other parts of Chapter 6 that I'd like to just briefly touch on. I notice, there's on the Monterey Highway issue in San Jose, and I know we've addressed that as required. I believe we've addressed that as required by the court, but it's an interesting conundrum to me in which I think the plaintiffs in the lawsuit are not from cities that are affected by the Monterey Highway issue. It's the city of San Jose, and the changes that would be made seem to be consistent with and embraced by San Jose and in their plan. So it's just one of those interesting things that you see people from one community, filing a lawsuit over issues that are in another community in which they're not affected, and that community wants to have those changes. And I know that's still not. We're not supposed to. I take it we're still supposed to step back because we need to look at those Atherton lawsuit claims and make sure that we're doing the right thing, even if San Jose fully embraced it. So I understand that, but it's just an interesting commentary on how the legal system works sometimes.
I would agree with you that it's important that we step back and look at issues, and I'm particularly interested in what a lot of the people on both sides had to say today, because that how they view staff report, because they put a lot of effort into this as well. So I think that it's productive to have everyone spend a little more time than the 2 minutes, and I think we've done that here today, where we've gotten a better understanding of the issues that are being presented by various organizations. So it will make it. I don't know that it makes it easier for me to make a decision, because there's a lot of literature or a lot of things that we've discussed, a lot of things that we've read, and I just want to make sure that the staff has considered all the input from each of these other sides, so that we're sure we're making the right decision when we go forward.
Yeah, and as I read the entire report, and particularly on Chapter 6, there's no doubt that the ultimate alternative has a lot to commend it. I mean, as you look at it, it truly is a balance, and I think I can see why people would think it's a close call, because there's something to be said for both, and I appreciate that's presented in such a way that we can step back and look at it as we see it, and we get to make that balancing decision rather than the staff. And so I appreciate that the data is there. I think those are I think I've gotten most of my questions out, Mr. Chair.
Thank you very much. Excuse me. Thank you very much, Mr. Hartnett. Vice Chair Richards.
Yes, thank you, Mr. Chairman. And I appreciate many of your questions, Director Hartnett, and I've been rapidly checking mine off as you've gone through them. But I'm struck by a couple of three things that I would like to ask staff. One in your comments with regards to general considerations and fiduciary roles and responsibility. As we have read through these documents in various areas, we also discuss cost, and certainly we're responsive to cost and the manner in which we manage the taxpayers' dollars. What I'm interested in is from a CEQA perspective. How do we import the costs into the decision-making process in addition to other environmental factors?
Well, for what we did in these documents, cost was a component of everything that we looked at. So, not one issue really outweighed the other. It was looking at everything across the spectrum equally, trying to, identify which would be the most superior alternative to put forth.
It makes it even more difficult. I mean, in some ways, it almost ends up being the leveraging factor because, as Jim did say, I mean, when you look at the Altamont and the Pacheco Pass alternatives, I mean, there's a lot to be said with either one of them. And so in some instances, as I've read through this, costs really become a major factor in consideration, certainly given the importance of cost to the taxpayers. I'm wondering also, is there anything in importing the idea of this blended system that causes any issues or concerns with regards to the court order of last November with the results of the Atherton 1 and 2 litigation? In other words, the contemplation of a blended system is not inconsistent with what we are able to move forward on today.
Correct. We see the blended system as an implementation strategy of the overall project.
Okay.
And we did discuss that specifically in Chapter 5 of the partially revised document in front of you.
Okay. Thank you. And with regards to something that I had read also, and I'm not sure if you mentioned it earlier, with regards to station stops between Merced and Gilroy, is there any likelihood that with our action today that that would change? In other words, by future boards or future decisions?
It would have to go ahead.
Yeah, I might want to just speak to that. Under Proposition 1A right now, there's it prohibits the station between Merced and Gilroy. So theoretically, there may be an opportunity to change that law, but in fact, it would have to go back to the people as for an amendment to that Prop 1A law. So as an initiative, and probably very unlikely.
All right. Thank you, Mr. Flens. Just with regards to responsiveness to the public comments today, which I found extremely helpful, from a staff and management's perspective, is there anything here today that you've heard that causes you to perhaps suggest to us that either we haven't studied this or considered the comments that have been raised here today to a level that we would feel comfortable that we have performed the responsibilities that we have in looking at all the environmental alternatives and implications of this action today?
No, because like I said, we've had extensive public participation throughout this process. We've responded to almost 5,500 comments specifically. And, in each of those we responded, with specific answers. And if they had, some relevance to the document, we made sure the documents were updated with that specific information. So I think, what we have heard today and what we can continue to hear are items that we have studied at some point through the document process.
You agree with that also, Mr. Flens?
Yes, I do.
Okay. Thank you, Mr. Chairman.
Thank you. Other questions? Other members? Mr. Schunbrunn, you referenced a letter. Did you send us a letter today? We have a letter. I'm sorry?
I did, yes, and there's a copy with your
One copy, okay. Just so that just so we have that on the record, I understand. Okay. Okay, I had not seen this until this moment. We also have a letter from Mr. Flashman that I think most of us have seen. What I'd like to suggest at this moment is that we take a break just until noon, about 7 or 8 minute break. I'd like to look at this and make sure that members have the opportunity to avail themselves to review it. I think, this board understands the significance of this decision, and I know that we've gone through these materials. We want to make sure that we're hearing from and considering all the opinions here. So why don't we break until noon, maybe 5 afternoon, and then let me just say to Mr. Schönbrunn, you have other copies of it? One more copy, thank you, sir. Okay, we'll break till 5 afternoon, and let me just say to the rest of the public, I do understand everybody's items before us are important today. We do have this as a legal matter that we have to perform, which is why we put it first. So I appreciate people's patience. And then once the board acts on this, we'll immediately go to public comment on other things. So we'll be in recess for what looks like 10 minutes right now. Thanks. Ms. Chief is going to get Mr. Umberg. We're a little thin on quorum today. Oh, he's here. Lisa? Thank you. Thanks. Okay, we'll reconvene. Members, I know we've gone through questions prior to what's the pleasure of the board in terms of taking action today? Any comments or thoughts that members want to share, dialogue, discussion? Mr. Hartnett.
Yeah, I'm prepared to take action today on the 6 items that are in the recommendations. I thought that Mr. Flashman made an excellent point about, even if we have the legal justification to make a decision in a particular way, we still have to step back from that and say, well, what's the right decision beyond the fact that it's legal, and we may have more than one legally acceptable alternatives, and I read the materials and listened to the testimony and heard the staff report, and as this relates to the alternative question. I feel that there is a lot to commend both of the alternatives alignments, both the Altamont and the Pacheco, and so I think in that means you have to, from my perspective, you really have to look at it and say, okay, how do I balance the various considerations, and I'm not relying just on the document in terms of the staff recommendation is how to balance. I think it's, we get to rent our own balance, and in doing that, it's just, frankly, with a lot to commend each, in my heart of hearts, I still think that Pacheco is the preferable alternative, and so there's a bunch of factors that go into it. They're addressed in the revised plan. And so that's just how I look on the alternative question and the choice of how that comes down. I think in terms of the technical issues of, certifying, I think the document adequately from a legal point of view addresses those things that the court required to be addressed, and so I'm comfortable with that. And I know the issue of the blended approach is a hot topic, obviously, and that's probably a closer call than some of the other issues. But, I think that it's been dealt with the best it can at the programmatic level, based upon the stage of where that is, and there's substantial more work that would have to be done on that at the second tier level, which is why I think in the recommendations there's the direction to both proceed with the second tier environmental planning and to direct the staff in that for the San Francisco to San Jose segment to focus on the blended system approach. And I think that's the appropriate place for that to land at this point. So those are my comments on, I think that really relates to all 6 of the action items that are subsumed within this particular agenda.
And I apologize, Mr. Hartnett, because I was looking at something. So in terms of action today, what were you proposing?
There was only 1 or 2 brilliant points you missed, but I feel that I feel informed sufficiently based upon the documents and the testimony and the verbal staff report, as well as the conversations that we've had here in public. I feel informed sufficiently to be able to make a decision and to move on the 6 action items that are part of the recommendation.
Okay.
I personally do.
Other comments and so forth? I appreciate that, and I just I also feel we should move forward today. This is a difficult decision, obviously one that I say our predecessors, probably Director Umberg was part of this, have faced before. I wanted to make 2 quick points. First of all, in terms of the statement of overriding conditions that was offered up today, that was a red line document provided. It really was, those red line changes were really put in there with the purpose of reflecting some of the thinking and changes that came out of the 2012 revised business plan. There's 2 issues in my mind. One is the question of the network alternative, Pacheco versus Altamont, and the other is this issue that has been raised. And Mr. Hartnett, I want to just again thank you for your tremendous work on the blended system issue. Let me deal with that one first very quickly, which is one of our speakers today, Ms. Hamilton, made a point that we've been talking about the blended system, but we're really not trusted, and that comes with the territory, I suppose. But I think that there's no question, if one looks at the range of decisions that this board has made over the past 6 or 7 months, that we do see the blended approach as as an appropriate way to build a high-speed rail system in California. The language that has been proposed today would indicate that as we go forward at the project level, not the program level, but at the project level, that we would be directing the staff to work, I believe the language says primarily on the blended approach. I would actually be amenable to a slight amendment of that to say exclusively on the blended approach, because I think that's really been the sense of of this board. So while I know that there are still some questions because we're not changing that part of the programmatic EIR, I do think we want to make it very clear that at the project level, that is the direction that we're giving to staff. It's also important to note that in adopting this language, we're not making a decision today with respect to that blended operation or blended system, but we are saying that as we move from the program level to the project level, staff is directed, and I would say, if my colleagues agree, to focus solely, to use a word, on the blended approach in the peninsula. which brings me to the issue of the Altamont versus Pacheco. This is very difficult for me because I've came to this board probably with some layperson's opinions about it. I've had to inform myself from the record over the last several months, and in the last week or so, inform myself more fully by reviewing these documents, which I have done. It's a lovely way to spend a Sunday afternoon. And, as I listened to the various speakers, I guess I am concerned that I would like to believe that we can handle the growth-inducing issues on a Pacheco route. I do understand that the Altamont route is alleged to have greater connectivity to other systems, but there may be some things as we go forward, particularly given our work with Caltrain and BART to San Jose and so forth, that I think can address some of those issues. And there may be other ways to deal with this. My biggest concern is just that we do have the problem with train splitting serving San Jose and the time requirements, and that's where I'm concerned that our mutual responsibilities of minimizing environmental impacts and also addressing the legal requirements of Prop 1A need to be harmonized. So I think that probably is the direction that we need to go. Based on the record that we've had before us and the testimony that we've had before us today. Any other members want to make any comments at this point? Motions? Council, let me just ask, in terms of the formalities, are there things that at this point, is it simply the motion, or how should we proceed?
What you have before you is a resolution, 12-17, and so that's what you would be adopting. But I just heard you, Mr. Chairman, indicate that you wanted to have a more direct or not a preference, but a direction to staff more clearly that we move to the blended system approach. So I have the resolution here, and I'd just like to come up and may I approach the bench and give this to you so that you can see the exact language and maybe suggest language changes.
Right. I'm sorry, so I lost my place in my book. Right. Right, so members, right now this reads, the authority further directs staff that a second-tier project-level EIR for the San Francisco to San Jose section of the high-speed train system shall be focused on a blended system approach. I would propose adding the word solely, S-O-L-E-Y, after the word focused. Mr. Hartnett, is that, are you comfortable or uncomfortable with that?
Well, as long as it's passes the legal muster, I'm comfortable with that. I think it's a good word to add.
Okay.
Yeah, that would be fine. You could add that word. There wouldn't be any legal problem.
Okay. All right. With that, do I have a motion?
Mr. Chair, I'd like to move the resolution as stated with the one-word amendment that was just inserted and including as we the revised statement of overriding considerations in the addendum to the partially revised final program EIR that we have as part of our packet as well.
I'll second that, Mr. Chair.
It's been moved by Mr. Hartnett, seconded by Vice Chair Richards. Secretary, please call the roll.
Vice Chair Richards?
Yes.
Mr. Umberg?
Aye.
Mr. Hartnett?
Yes.
Mr. Balganorth?
Yes.
Chairman Richard?
Yes. I want to thank Mr. Felenz and all the staff that we heard from today, Mr. Freitag and other members of the staff. I want to thank our attorney support team from the Attorney General's office who's helped us with this. And the last point I want to make on this is that the High-Speed Rail Authority is very interested in doing the environmental doing the environmental work in the right way. I think it should be noted that when the judge's preliminary ruling came out, we did not wait for a final ruling. We did not appeal that. We began immediately to try to remediate the deficiencies that were identified in the environmental documents. And a lot of people worked very hard over the holiday season to deal with that. And I want to express gratitude, I'm sure, on behalf of all my colleagues on the board. So thank you for that. Members of the public, thank you for your patience. We'll now proceed to public comment. And we will start with elected officials and take these comments in the order in which they were received. We'll begin with Fresno Supervisor Henry Perea, the hardest working man in show business, as they say.
Mr. Chairman, members of the Commission, a lot of hardworking people in this room, a lot of important decisions being made, and thank you for your leadership once again. Just a brief update. Business plan receiving very good response in Fresno County. Our teams are out in public engagement every day, talking to groups, talking about the plan, answering questions, and there's a lot more clarity to the direction we're heading in high-speed rail, and a lot of that's because of the hard work and heavy lifting that you all have done in working with the governor, so thank you for that effort. Mr. Hartnett, you made a comment earlier that prompted this comment that's come in with respect to opinions, and many times when they're grounded on fact and sometimes just on opinion. And, I was struck yesterday with the hearings that are occurring, and I know there's folks who are concerned about high-speed rail, and they will continue to be until it's done. But that's just the way it is, and that's okay. But what concerned me yesterday was a presentation by the LAO's office at the Senate. I think it was very opinion-based, very inappropriate in how they presented themselves and how they treated representatives of this authority. I think if they would have read the business plan, probably most of their questions would have been answered, and they would have understood and remembered their role is to provide independent analysis and review and recommendations. And I think all they did was tell folks yesterday why it was not a good idea and not weigh the advantages or opportunities of high-speed rail. So I think that they have a credibility issue, I think, with a lot of folks, and I'm speaking obviously as a supervisor representing Fresno County, but I was very disappointed in their presentation. But by saying that, I want to compliment you again for staying the course, dealing what you have to do to get this project moving forward and listening to the public. So thank you very much.
Supervisor, thank you. Supervisor Richard Valley from Kings County. Supervisor, thank you for your patience this morning.
Good morning, Mr. Chair. Richard Valley, Kings County. Mr. Chair, I realize this is the third time in the last 24 hours that I've given testimony before you, but I think we could both agree we got a lot of catching up to do.
Yes, sir.
Yes, sir. I want to thank you for coming to Kings County on a Tuesday, April 3rd. We look forward to having you back in Kings County with the Board of Supervisors on May 9th. But as you heard yesterday in the Assembly and the Senate hearings, we continue to be disturbed that although we've physically been here before your board many times to voice our concerns on the negative impacts to Kings County of this project, and specifically to relay the importance of our Amtrak stations in the city of Hanford and the city of Corcoran, to see the language that was adopted last week in San Francisco by this board that lays out the plan for the closure of those Amtrak stations continues to send the message that we are still being ignored. Members, on top of the shortcomings as outlined by the LAO office yesterday at the Senate hearings, I'm here to represent those real problems in Kings County. My hometown, the city of Corcoran, we're facing 3 possible alignments that will destroy our downtown, and to now be looking at the loss of our Amtrak station, that's going to affect real people. Every morning as I drive by that station, you see the same group of folks out there waiting to take that train, that Amtrak, to get them to their places of business. They're not there to take that Amtrak to go on vacation. They're there to go to work. So again, members, I represent to you that Kings County, we are in the fight of our lives, and we look forward to seeing you May 9th. Thank you, Mr. Chair.
Supervisor, let me just say quickly, number one, you are right. Our business plan did indicate the shift of the Amtrak service, and so you are right to be standing here protecting your community in the way you are. I just want to give you assurances that we will work with you and our sister agency at Caltrans to have a rational plan for protection of that service.
And I appreciate that, Mr. Chair, just as long as that is your projected statements, no matter what audience you're in front of.
That's right.
Thank you, Mr. Chair.
I look forward to seeing you again, Supervisor. Thank you. We next have a request that the Mayor of Palmdale, Jim Ledford, could not be here in person, but Mr. Behan is here, and I believe that the Mayor is going to join us through the magic of electronic technology. With fingers crossed.
I just need the gentleman in the back to switch the screen.
Someone needs to switch the screens in the back.
The State High-Speed Rail Authority's decision to embrace the Antelope Valley alignment truly is proven to be the right decision. The City of Palmdale has a long history of involvement with high-speed rail in the state of California, and once again, we've been able to prove that the Antelope Valley alignment is in the state of California's best interest in regards to employment, economic development, air quality, meeting our air quality goals for the region, and certainly congestion management are all benefits of a high-speed rail system through the Antelope Valley. Now, here we are at the Palmdale Transportation Center, where really is the investment by the city thus far in our intermodal system here in Palmdale with a Metrolink platform and station, bus transfer, taxis, bikes, all come together here in Palmdale at this location. However, the state high-speed rail now connecting will reinforce that investment, and it will allow specific plans for Transit Village to move forward, where transit-oriented development has room to grow, and we have a specific plan put together just for that use here in Palmdale. And Palmdale really is poised to be the destination for a true interstate high-speed rail system. When we look at what Desert Express is doing and our ability to connect to that, and I see seamless service from Los Angeles to Las Vegas or San Francisco in our future. The authority's business plan embracing the gap closure between Palmdale and Bakersfield truly does bring a complete system to the state of California. And our investment in the blended approach allows us to realize benefits we've already invested in as far as our transit system that we know in Los Angeles right now. To connect to that blended system allows us to realize a synergy and a leveraging of that investment to, I believe, is going to stimulate those existing systems. It's going to bring increased ridership, and I think greater viability long-term for our transit plan for Southern California. So the genius, I think, of a blended approach does realize that investment. It does recognize the gap closure between Palmdale and Bakersfield, and it does work with what the region has already determined to be our priorities. And currently, regional population forecasts estimate the Antelope Valley population could exceed 1 million by the year 2020. Palmdale is the linchpin to moving this project forward and finding early operational success. So we believe the High-Speed Rail Authority's decision to come to the Antelope Valley with a stop in Palmdale at the Palmdale Transportation Center truly is in the state of California's best interest, and we believe you're working with the synergy that already exists here in Palmdale.
Okay. Thank you. It's making me wonder if I should send a video of myself to the Kings County Supervisors meeting on the 9th. So, just kidding, Supervisor. I'll be there. Our next speaker is the City Manager of Corcoran, and I apologize, Kindon, is that Meek?
Correct.
Oh, good. I got it. Mr. Meek, good afternoon.
Thank you, Mr. Chair, members of the board. I express gratitude foremost for your assurances to reconsider and look at the issues dealing with the Amtrak services to our community. Representing the city of Corcoran, I want to note that we have previously submitted resolutions and letters opposing high-speed rail for the loss of jobs, farmland, and neighborhoods, and also the environmental justice issues that have not been that have been overlooked in the EIR. At this time, I just want to address, again, the Amtrak services and the proposed elimination of those services to our community. Amtrak makes 12 stops daily to Corcoran. In the fiscal year 2010, there were approximately 27,000 boardings from the city of Corcoran. Residents rely on Amtrak for employment opportunities, medical services, education endeavors. They carry out activities at the county offices in Hanford, and they use the Amtrak to connect to regional hubs outside the county. Furthermore, I hope the board understands that the loss of Amtrak would not only cripple those services, but it would also decimate our city-owned transit, our bus system, that relies on Amtrak and is intricately connected to that. So thank you.
Thank you, Mr. Meek. Let me repeat to you what I said to Supervisor Valley. We will commit to working with you, and we understand the importance of this service in your community.
Thank you.
Okay, next we have Stephen Valenziano, followed by Michael Murphy, followed by Michael Behan.
Mr. Chairman, board members, my name is Steve Valenziano. I'm a resident of Santa Clarita, and I'm here today representing a community working group or task force which has been formed to gather community input on the high-speed rail project in order to convey to high-speed rail authorities the issues and concerns our community has with high-speed rail. I'm also a development partner in the 90-acre approved Vista Canyon mixed-use project, which would be impacted by high-speed rail. By way of overview, our community task force agrees with the California State Legislative Analyst's Office that the legislature should delay any decision to proceed because there are so many funding uncertainties. At this juncture, the state would be taking a large and unprecedented risk. Unfortunately, in California's current condition, there's too much economic and budgetary uncertainty and too much political dysfunction to pull off such a massive public works project. What is much more certain, however, should the project actually happen, is the negative impact the high-speed rail project, given the alignments under study, will have on our community. The first negative impact of primary concern relates to school safety. High-speed rail is planned to run within 400 feet of two adjacent elementary schools containing over 1,000 children. The train is slated to be running at 200 miles per hour. The engineers have told us not to worry about the possibility of accidents or derailments, but the Sulphur Springs School District and the community are very worried. Beyond the issues of safety, school officials are concerned about the frequency, noise, and vibration of the trains and the adverse effects on the learning environment. Of course, there are other negative effects as well. The large trenches and viaducts will forever change the landscape of the east side of Santa Clarita Valley, with no benefit accruing to anyone in the Santa Clarita Valley. Sound, vibration, and view impacts will affect over 2,000 homes in the area. Alignments under consideration would take at least 23 homes and a church, along with a major 90-acre newly approved mixed-use project slated to be the new job center for the eastern side of town. In conclusion, the Santa Clarita Valley High-Speed Rail Task Force earnestly requests that if and when high-speed rail finds its way south to Palmdale, that you continue to utilize the Antelope Valley Metrolink line under the recently adopted blended approach, sparing our community from the high-paying, no-gain intrusion of high-speed rail. Thank you,
sir. Thank you. Mr. Michael Murphy, followed by Michael Behan.
Good afternoon, Chairman Richard and members of the board. I am Michael Murphy. I'm the Intergovernmental Relations Officer for the City of Santa Clarita, and I'm here at the request of the City Council. The City of Santa Clarita is located in northern Los Angeles County. We're a city of 180,000 people immediately north of the City of Los Angeles. The area that is contained within your agenda item 9 today regarding the supplemental analysis for the Palmdale-Sylmar area, we are included in that segment. As noted in the staff report, the City Council has not as yet taken a formal position regarding high-speed rail. At a City Council study session in September of 2010, the Council indicated that there were concerns over noise, vibration, and impacts or visual impacts to neighborhoods in the eastern portion of our city. But I want to point out that the Council has some very special concerns at this point in time regarding the proximity of the proposed alignments that are in front of you today to two schools in our community. As you heard earlier, they are approximately 400 feet away from the proposed alignments. One option that was looked at earlier and was referenced in your staff report is to extend an existing tunnel an additional 2 miles east, which would go under some of the neighborhoods that are potentially impacted, the Vista Canyon Ranch project, which the council had previously approved and is a job creation center in that part of our city. And it's been eliminated at the staff level, and I would ask on behalf of the city of Santa Clarita that you put that consideration of an additional tunnel back into your EIR. Also, the City Council would encourage the Authority's Board of Directors to continue to direct your staff to have meaningful dialogue with the citizens of our community. Your recently adopted business plan is a significant change to our community, and the City Council believes it's very important that the dialogue continue in a very meaningful way. On behalf of the Santa Clarita City Council, thank you for your consideration of my comments.
Thank you very much, sir. We appreciate your coming here today. Mr. Behan.
Good afternoon, Mr. Chairman, members of the board. Thank you, first of all, for allowing us to present the video message from Mayor Ledford. We appreciate it.
I should have known when a politician told me it was only going to be 2 minutes that that might not be quite true.
2:40, right around there. I actually got to be a co-producer in the deal, so it was my first time. It was kind of fun. Anyhow, we understand that the alternative selection process is difficult. We're very excited to move forward, and we're ready to embrace this. Adding a few more comments to what the mayor had to say, that we feel like we've set the foundation to accommodate high-speed rail. We've made necessary investments, infrastructure investments, and again, we're committed and excited about high-speed rail in Palmdale and the Antelope Valley. In terms of the alignments, I think we've been on record in mentioning, and the mayor said it again, that the Palmdale Transportation Center, which is an existing Metrolink station, is along the easterly alignment. So we would, hopefully, when the environmental document goes through, the selection will be an easterly alignment and connection to the Palmdale Transportation Center. The PTC, as it's known, is a center of existing and future modes of transportation. It is also part of a transit village specific plan, which is a transit-oriented development, and we see it as a great opportunity to expand this area to accommodate a future high-speed rail station, and we believe that it provides the best opportunity for multimodal connectivity. As the EIR process moves forward, we'd be happy to answer any questions and provide any data. And again, Palmdale is very excited about high-speed rail. Thank you.
Thank you, Mr. Behan. Jesus Vargas, followed by Craig Martin, followed by Marvin Dean.
Good afternoon. My name is Jesus Vargas, principal at VSE, a DBE firm. We provide program management, construction management, and public relations. I'm here representing the California Hispanic Chamber of Commerce. We're in support of the item number 7, the draft Small Business Disadvantaged Enterprise Program. Specifically wanted to highlight 3 areas that we're in support of, which include the added reporting. We definitely would like to see the small business goals broken out by group, DVBE, minority business type, women business type. The second item we like to highlight is the enhanced outreach that has been identified that's going to be augmented to highlight the different opportunities for the small businesses and the DBEs. And the third area is that of offering the chamber we'd like to offer to stay involved as the program gets unfolded. There's going to be, I guess, a business advisory council that's going to be discussed a little later. We're glad that one of our representatives is identified, so we look forward to staying engaged. I feel that, taking off part of my hat, that an independent outreach effort could be done better if they reported directly to the High-Speed Rail Commission, and look forward to enhancements in that area. So thank you very much. Gracias.
Thank you. De nada. Next is Craig Martin. Good afternoon, sir. Followed by Marvin Dean.
Mr. Chairman and members, my name is Craig Martin. I represent Senator Curran D. Price, Jr., the chairman of the Senate Select Committee on Procurement. He wants to offer his support for the California High-Speed Rail Authority's Small Business and Disadvantaged Business Enterprise Program. As chair of the Select Committee on Procurement, He wishes to express his support for the California High-Speed Rail Authority's revised Small and Disadvantaged Business Enterprise Program and urge the California High-Speed Rail Board to approve this vital program. The committee's mission is to ensure that small businesses fail to participate in state contracting and procurement opportunities. As part of his commitment to this goal, he has authored legislation, Senate Bill 734 last year, which requires the California High-Speed Rail, among other things, to create a small business outreach and retention plan, as well as establish participation goals on this multi-billion-dollar infrastructure project. He wants to thank the California High-Speed Rail for taking the initiative to pursue these same goals through its SB and DBE program. He further wants to acknowledge the executive staff members, Chris Ryan, Patricia Padilla, Olivia Fonseca, and Karen Green Ross, for their diligence in constructing this important document and keeping him updated on its development. He further wants to acknowledge that the California High-Speed Rail has accomplished a major milestone with the creation of this program. He looks forward to his continued working relationship as we strengthen and fine-tune its implementation to ensure that the state's small businesses, micro businesses, and disadvantaged veteran business enterprises are represented to the fullest and fairest extent on this historic California High-Speed Rail project. Thank you very much.
Thank you very much. Mr. Martin, would you please convey our appreciation to the Senator for his leadership and let him know that in conversations we've had with our staff, what we've indicated is a year from now we want everybody coming to us to look at how the best gets done.
He wants to apologize. He couldn't make it here today, but he wants to tell you that he is very much impressed with the outcome of this document you produced.
Thank you very much. Thank you. Yes, Mr. Dean, good afternoon.
Good afternoon. I wanted to start with bringing my sign, and the chairman seen the sign when he came to Bakersfield and had the debate with Kevin McCarthy, and I wanted to remark on, I think that the chair showed his leadership skills and showed that he's the right man for the job at this time. And one of the reasons I brought this sign, because Kevin told me later, I know Kevin, he said, I clearly noticed your sign out there, and it made me think. And we also take this sign every time we go to public meetings where there are opposition, so that we can speak not in opposition to those that are in opposition, but to talk about the benefit of high-speed rail. Now, to get to my point, there's a handout that I've given you all, and it's about 4 items on there, item 5, 6, 7, and 8, that we had some concerns with. The handout goes into the concerns, the background, and the requests. So I'll just briefly just speak on them. Item number 5, I understand you're going to pull the agenda, but I didn't pull from the agenda, but I didn't hear about item number 6. And our concern is that we should have these every contract that the board enter into should have that 30% goal as a part of it. None of them be exempt. So that's the reason for that. And then the second one there I want to speak on is a small business plan number 7. The only thing we're asking is that there be a separate goal as a part of that 30% goal to deal with DBEs. And then the one that I'm going to close on, number 9, I'm going to say I support the staff recommendation, which is number 10. 10 and 9 is the same. But one of the things I'm a little disappointed on, and that is number 8. As you notice, number 8, I asked for there be transparency in the selection of the people that are going to serve on the Small Business Council. There's no representation adequately in the Central Valley. Our organization, the San Joaquin Valley BCA, and the current minority contractors asked to be considered. We're not been considered. I don't know whether it was retaliation or it was just an overlook. We believe that the project's going to start in the Central Valley. We need to have trade associations in that valley getting those people ready. And I just wanted to raise that. So thank you for the time.
Thank you, Mr. Dean. I'll ask staff about that. I noticed there were some vacant slots there, so your point is well taken, sir. Next is Ted Hart, followed by Mark Powell, followed by Dan Dolan.
Yes, good afternoon. I want to speak to Prop 1A and the requirements. I would like to read quickly from the current revised draft business plan. Page ES14, if required, a full build option for Phase 1 could be completed by 2033 at an incremental cost of $23 billion in year of expenditure dollars for a cumulative cost of $91.4 billion. If you then would take and add to that the exponentially numbers that are required for a full statewide system, you'll arrive at $140.6 billion. The question that I have concerning this issue really is
that in Prop 1A, when you read the text of it, which I'm sure everybody has looked at, it references high speed, high speed, high speed. Nowhere will you find a blended word. I want to then move over to the text of the proposed law, 2704.09, the high-speed train system to be constructed pursuant to this chapter shall be designed to achieve the following characteristics: electric trains that are capable of sustained maximum revenue operating speeds of no less than 200 miles an hour, maximum nonstop service travel times for each corridor that shall not exceed the following. Let's go back and say nonstop again. Since we're in Sacramento, and I happen to live here, we're looking at Sacramento to Los Angeles, 2 hours and 20 minutes. So I'm going to go over and get on the train. I'm going to take an Amtrak train from Sacramento to Merced. Then I'm going to get off. I'm going to get on a high-speed train that runs to L.A. I submit to you, if you can figure out how you're going to do that in 2 hours and 20 minutes, it would be very interesting. Thank you for your time.
Thank you, sir. Mark Powell, followed by Dan Dolan, followed by Rich Dryden.
Yeah, I too wanted to comment on your lack of a funding plan for your initial operating segment. You may gain access to $6 billion to begin work on the first construction of the initial operating section. But AB 3034, the law behind Proposition 1A, requires the following. The funding plan shall include, identify, and certify the sources of all funds to be invested in the corridor and the anticipated time frame of receipt of those funds based on expected commitments, authorizations, agreements, allocations, or other means. Your funding plan lacks between $25 and $30 billion in expected commitments, authorizations, agreements, or allocations. Moreover, the authority is not to be the judge as to the adequacy of your funding plan. AB 3034 calls for a report or reports prepared by one or more financial services firms, financial consulting firms, or other consultants, independent of any of the parties, indicating that construction of the corridor can be completed as proposed in the plan. You have no such report or reports, and in fact, you have no funding plan other than hoped-for federal dollars far off in the future. The law behind Proposition 1A was written to prevent exactly what you are struggling to do now, and that is to begin construction before all funds necessary to complete the initial operating section are reasonably secure. The truth is that your last real funding plan was drafted by a financial consultant in 1999 and released with your 2000 business plan. That funding plan called for a temporary sales tax increase of either a quarter cent for 20 years or half a cent for 10 years to pay for a $25 billion statewide system. And now that tax would have to be increased about fourfold since your costs have escalated 4 times faster than inflation. Thank you for your time.
Thank you, sir. Dan Dolan, followed by Rich Dryden, followed by Paul Guerrero.
Hello, Mr. Chair and board
afternoon,
members.
sir.
Dan Dolan, Western States Title Services, and also representing Stewart Title. I gave each of you a copy of a letter from Stewart Title,
Yes.
and I have one for Patricia Jones and for the representative from the AG's office. I want to commend you today for your decision to approve the partially revised program-level EIR and also the work you've done to get the state legislature the revised business plan so they can make their decision hopefully favorably for $2.6 state billion Prop 1A money and to enable us to get the $3.3 federal billion that's earmarked. But I want to caution the board and ask that you will seriously consider informing Governor Brown and his administration that there is a need to have title insurance that reasonably covers the cost of the new 300-mile system. And I propose $300 million might be a good number. Your current regional consultant, Bender Rosenthal, has an $18 million advanced service contract, and Bob Morrison and Cindy Bender, they're really only obligated to give you face title policy of hundreds of millions of dollars, hundreds of thousands of dollars, less than $1 million. So it's like if you treated this like hazard fire insurance, it'd be like building your system and having 1/300th of the amount of insurance that you really should have. And I just want you to consider the risk mitigation of this and ask Thomas Flens to recommend to the board that Stuart Title be given an opportunity to partner with Bender Rosenthal and be furnished with a copy of their advanced service contract so they can work together.
Thank you, sir. Rich Dryden, followed by Paul Guerrero.
Good morning. I'd like to thank the board for your service, to volunteer service in a very difficult position. You don't make a lot of money to do it, and we appreciate that. I'm in my 7th year as the executive director of the California Disabled Veteran Business Alliance. These comments are on the small business plan. Our alliance has been actively involved with California High-Speed Rail staff and Padilla and Associates regarding your small business plan. We made a significant input to you during the public comments period, have met with your staff, and have corresponded by phone and emails over 30 times. Our organization was founded to support the state's DVBE program and provide oversight when needed to assist state agencies in meeting the 3% DVBE goal in state contracting. As now written, your small business plan has no goals specifically established for DVBE participation, nor does your agency have a small business and DVBE advocate position, although I understand that's been subsumed by your SBLO. At the beginning of your hearings, we made comments some 2 years ago stating that the 25% small business and 3% DVBE goals should be increased to 30% and 5%, and that DBE, Disadvantaged Business Enterprise goals, should be considered not to interfere with the small business and DVBE goals, and we maintain that position. However, your plan is now written does not fence any DVB goals, and that is unacceptable. We understand that in your planning you had to consider state-funded projects as well as those which include federal dollars, and it is your intent to use SB and DVB goals in the former. However, you have presumed that when federal dollars are included in allocated funds that you must have DBE goals and cannot add DVBE goals, similar to what is done in the federal DOT Disadvantaged Business Enterprise program under Title 49. One of your actions has been to enter into agreement with Federal Rail to use best practices of Title 49 program, and your presumption in the building of your small business plan is that FRA controls what goals are in the high-speed rail contracts with federal funds are included in the allocations. Our alliance refutes that presumption, noting that FRA has statutory authority under CFR 49, has no statutory authority, and they can only advise what goals the high-speed rail uses. As now written, a small business plan, if approved, would allow all California high-speed rail projects to be completed with no DVB participation. That is in violation of state law. As such, we demand.
Could I just ask you if you could both try to finish up, and then also if you could provide, if you have a copy of your comments, which we can then review as
Yes, sir, I can lead a copy.
Thank
I'll
you.
finish by saying we demand that you table the vote today and work with our organization and others to restructure this plan to bring it in line with state law. Thank you.
Thank you, sir. Paul Guerrero, followed by Diana Lacombe, followed by Frank Oliveira.
Chairman Richard, board members, my name is Paul Guerrero. I represent La Raza Roundtable of California. I'd like to talk first on items 5 and 6, and we request that any amendment to existing contracts, such as those set forth in items 5 and 6, include the addition of a 30% small business goal. That be added into all contracts. On item 7, review and approve of the revised small business DBE program. We support the approval of the revised program and would like it to include a 10% numerical goal for DBEs. Item 8, that item reviews and approval of the Small Business Advisory Council, and we support the formation of the council and recommend that you increase its membership to 25 organizations that will give associations that have participated in the structuring of this and so forth over the years, like Marvin's and others, that will bring them onto the advisory council. There's the Black Chamber of Commerce. Fred Jordan has been instrumental in this, but he's not on there. and ourselves and so and other organizations, and we would appreciate their being included. And that's simple. Just increase the thing to 25 members. Okay? Thank you.
Thank you, Mr. Guerrero. Diana Lacombe, followed by Frank Oliveira, followed by David Schwagel.
Good afternoon, Chairman Richard, Authority Board members. I'm Diana Lacombe, President and CEO of APAC of California. APAC is requesting that the authority set a minimum disadvantaged business enterprise goal of 10% within your overall goal of 30% SPE goal. A 10% DBE goal is the minimum standard set by U.S. DOT on federally funded projects. The authorization for establishing a DBE goal comes directly from FRA in their September 15, 2011 letter to the authority in response to our Title VI complaint. You have copies of that letter in front of you, so I would refer to page 3, items 1 and 2. And I'm not going to go through every word. I'm just going to kind of highlight it. 1, the grantee agrees to provide maximum opportunities for small businesses, including veteran-owned businesses and service-disabled veteran-owned small businesses. And B, implement best practices consistent with our nation's civil rights and equal opportunity laws, ensuring for non-discrimination of protected groups. 2, an example of a best practice under B above should be to incorporate key elements of the DBE program, C49 CFR Part 26, in contracts under this agreement. This practice would involve setting a DBE contract goal on contracts funded under this agreement, contracts that have subcontracting possibilities. The goal would reflect the amount of DBE participation on the contract that the grantee would expect to obtain absent the effects of discrimination on this contract. Whether by commission or omission, the DBE community has been damaged by being excluded from this project. It is within your power, this authority board's power, to do the right thing. So please do the right thing and just set a 10% DBE goal today. Thank you for your attention.
Thank you, Ms. Lacombe. Mr. Oliveira, Frank Oliveira, followed by David Schwagel, followed by, looks like Chris Coles. I hope I got that right. Good afternoon, Mr. Oliveira.
Good morning. I'm here to represent the citizens.
Good morning in Hawaii, I think.
Good afternoon.
Can we reset the clock for Mr. Oliveira?
Thank you. Okay. I'm here representing, as usual, the citizens for California High-Speed Rail Accountability. We were created, and a lot of people get tired of hearing this, because in 2010, the High-Speed Rail Authority decided to come through Kings County with very little information for us. Our local governments and the population attempted to work with the High-Speed Rail Authority for about 1 year. And when we became clear that we were being ignored, things became a little bit more tense. As a result, the High-Speed Rail Authority broke off communication with our local governments. As far as individuals, we were told that our concerns would be addressed in the Environmental Impact Report, which they weren't. All of that said, things have changed. After we were disrespected, our civil rights were probably violated. Bagley-Keenan was certainly violated, just for daring to ask questions. But that's changed. We have a new mode going on, and we appreciate that. However, coming to Kings County and meeting with people to see the problem, and then coming to Kings County and speaking with our local governments one time with no answers, does not solve the problem when the project races forward. I've been in Sacramento for a week. I've listened to hearings all week. We are aware that our Amtrak is going away south of Merced, that our population will not be serviced, that people who really use the train for commuting instead of driving will be disenfranchised. We receive 12 trains a day in that part of the valley. We demand 12 trains a day in the future. This is a serious problem. Thank you.
Thank you, Mr. Oliveira. David Schwagel, followed by Chris Coles, followed again by Chris Coles. Mr. Coles, we're going to ask you to, when you come up, to speak just once. Mr. Schwagel, good afternoon.
Yes, David Schwagel, Californians for High-Speed Rail.
As a professional engineer, having written numerous EIRs and published several papers, articles on the sustainability and carbon footprint characteristics of cars, planes, and high-speed rail, I rebut the LAO's lies regarding noncompliance with AB 32. As we know from Vision California's Scenario C2, Smart Growth Green Future, AB 32 compliance is definitely there. The bottom line, if not HSR, what are we going to do? Mow over numerous farms, completely wipe out areas to build airports and expand our roadways to accommodate the 60 million people and 24 million jobs by 2050, only to induce further development that will further take over farms? The bottom line is high-speed rail is the smart choice for our state's futures. And farmers, they are fairly compensated in France, and I encourage us to study the mitigation techniques that have been used to compensate those farmers in France. And as we know, with the CAHSRA's rural-urban connection strategies, keeping our farming interests alive is very key, because after all, the agricultural industry, it's the third largest in the world. And I also encourage us to explore options like the solar modules and the wind turbines installed on the farms, and so that the farmers can sell the power to the authority. And plus, the E-Roads made a great statement in San Francisco about an innovative stormwater collection system, and I encourage us to check out those alternatives as well. So the bottom line, high-speed rail is indeed the smart choice for California's future. Thank you.
Thank you, Mr. Schwegel. I understand Chris Coles is left. I just want to confirm that. Okay. Then next, looks like we have a tag team, Leanne Eager and Kristen Kawaguchi. I'm not quite sure how you folks propose to divide up your 2 minutes, but thank you for coming.
You get 2 for the price of 1. Good afternoon. I'm Leanne Eager, and this is Kristen Kawaguchi, and we're here from the EDC, and we're representing the young and the old voters for high-speed rail.
That would be the younger and the young.
We're vintage. And we just wanted to give you a quick update on what we're doing in Fresno as far as educating and informing our community, and that's our goal at the EDC. I know one of the things that Supervisor Perea talked about is he and I have been in the last 30 days on the service club circuit talking to our community about high-speed rail, about the new business plan and what's going on. We have also been holding meetings, and on February 24th, we had an informational meeting for those folks who are on the alignment, the businesses that are on the alignment. And I do want to really thank the staff of the High-Speed Rail Authority, Lance Simmons and his group, and Jeff Abercrombie, Patricia Jones and her team. When we need information, they are right there on the spot, and we think it's really important for the people of Fresno County and certainly all in the Central Valley to get as much information as they can. And we're planning on holding additional meetings in the next 90 days in order to inform our community about what's coming in the future. And as far as the young voters,
just wanted to say that since we came to last week's meeting in San Francisco, we've had an outpouring of support from all generations. We've had people contacting us and letting us know that they support our efforts. We've been already offered partners with other organizations, and wanted to let you know that we're mobilizing this group of young voters and young supporters. We're starting to educate the younger voters and gaining stronger support from this generation of tomorrow's influencers. So far it's been word of mouth. We've just been discussing with people, but we do plan on holding some kind of educational event later in the year for these young voters and younger generation of professionals, and we're excited about that. And to let you know, we just support you and know that you will keep and continue the vision of high-speed rail and what it will do for our future generation.
Thank you so much.
You made it.
Very nice. Very
Thank you.
well done. I'm going to apologize to this person from the FCOM group, Makita Shartukar. Please excuse me if I mispronounced your name.
You actually did a very good job. It is Makita. Hello. My name is Makita Shartukar. I am the CEO of the SEM Group. I am a small business, and I do specialize in outreach and optimization of small business infrastructure. I first would like to state that I want to commend the small business team and program because I do think that the revised program is admirable, and I see that a lot of work has been put into it. But in my opinion, the program is still very reactive versus proactive with SBE, DBE inclusion. We talk about high-speed rail's impact to employment and economic development. However, the current model being utilized still represents a lot of the status quo. I do have direct conversation with a lot of the top agencies who struggle in meeting the SBE, DBE goals, and I haven't really seen, as part of this program, the real innovative approaches that would be needed in order to meet the 30% goal that the authority has set. Here's why. A lot of the small businesses, unless they're certified, are not being in communication with this program. A lot of small businesses need a lot more time to scale their operations and to make sure that they have the proper infrastructure in place. So I highly recommend that the board and the small business program allocate more resources on the front end towards the education and capacity building of the local small and disadvantaged businesses in order to have the greater support of the communities at large, achieve the 30% goal, and more importantly, sustain that goal. I also recommend that if a Metro Protege program is implemented, that you actually set a target number of businesses that will be a part of that program. Thank you.
Thank you very much. I need to apologize to our next speaker, Mr. Ken Whip, who I had not realized is actually, I believe, an elected official of the Vice President of the Acton Town Council. Sir, are you here? Yes. I'm so sorry. I indicated we do take elected officials early, and I just missed it, sir.
I'm very sensitive about it.
You're probably more sensitive about how we affect the community of Acton as we come through.
Well, obviously, it's an ongoing concern, and that's why I'm here. We looked at the alternative analysis, and what it leads us to is, first of all, I have to be quite honest and do something that I warned the parties that I was going to do. I want to compliment Sarah and Dan, who work with us on a regular basis. I've spoken to you twice, and what I've said is please have them engage us, please have them work with us, because we're a sensitive area. We don't have any background noise where we are, other than me. That's about it. And so the train is going to have a huge impact on us when it goes through. Now, each time I've said, please have them work with us, they have. And I think the alternative analysis shows that. I don't know that it saves us. I don't know that it makes us ardent supporters. But I appreciate their efforts, and I appreciate whatever you guys did to get them to go there. Thank you very much. Also, I have complained at a couple meetings that we dealt with engineers. All we deal with is engineers, and they're good engineers, and they try and be responsive. But we never get to deal with you guys. So here's the dirty part of what I'm going to say. All of you are invited to the next meeting we have there, because they're flying right through the flak. You're feeling the flak, but they're right in it. And we'd love for you to see our community, understand our needs, and just see what we're dealing with when we try and accept high-speed rail. Thank you.
Council member, I'm not quite sure when, but I'll find a way to get there, at least speaking for myself. I've learned a lot by going to parts of the Central Valley, including Kings County and others. There's nothing like standing there on the alignment to get a sense of it. So
That's great.
We'll find a way, and we look forward to
We'll
that.
drive you around on the dirt roads and let you see our non-producing wells. Thank you.
I think we could use those for carbon sequestration and get some greenhouse gas credits. No, that's all right. Okay, the last speaker is Mr. Tate Hall, Fresno Metro Black Chamber of Commerce. Mr. Hall.
That's Hill.
Oh, sir, I'm so sorry.
Yeah, that might just be my cursive there.
No, it is Hill. Excuse me, Mr.
Yes.
Hill. I'm so sorry.
I'm Tate Hill, President of the Fresno Metro Black Chamber of Commerce, also the Vice Chair of the California Black Chambers Council of Chamber. Mr. Aubrey sends his regards for not being able to be here on today. Coming in support of the Small Business DBE plan with some 2 or 3 recommendations that might help reduce barriers for small businesses. Ron, regarding some of the reporting process as a way to help mediate some of that if the reporting could be done online or provided that information as relates to DBE outreach and SB efforts. Also, to set that information available online. Second, if there would be a way to form some type of third-party remedy through the board or some type of review committee for mitigation of issues around contracts. Right now it's all handled internally, administratively, through the Small Business Liaison Officer or the CEO. So if there are issues outside of that, the president really doesn't have a remedy other than legal action. Third was if there could be some component of monitoring regional SB, DBE outreach and regional contracting, while it might not be a contract or a goal, but that there's some way to increase opportunities for small businesses through monitoring that and also being able to report that. Again, just online-based reporting that allows for DBE community groups to assist in identifying qualified DBEs where there might be contractual gaps. And then just the re-emphasis, the critical part around subpart F on the supportive services. I think those are going to be really critical in making sure that you reach the goals, particularly the mentor-protege, certification, and communication. Thank you.
Thank you, Mr. Hill. Please tell Aubrey Stone that Dan Richard says hello. I knew him when I worked at PG&E, so thank you. That concludes our public comment period. I think we need a reality check. The unfortunate reality, and I want to put the blame where it's due because we always accept responsibility when it's ours. In this case, it's not. The owners of this building told us that we turn into pumpkins at 1:30. So they need their conference room back, and since they own it, I guess that's not unreasonable. We have a number of items in front of us. It looks to me like we're not going to be able to get through all of them today. We're going to have to put some over. I know we have people here on who've come for the SBE, DBE issue. I know we also have the alignment question. Mr. Folenz, you have a recommendation?
Mr. Chairman, for item number 6, we do have Ms. Wongesta and Mr. Ashley who could be available for questions if you want to take that item quickly. There was a memo that was written that I think explains what 6 is. And then if we could move to the 7 and 8, Ms. Papadilla is ready to give a very short presentation on that. I think those are important items.
Okay. And why don't you change the word important to more pressing, because I'm sure they're all important.
Yes, sure they are.
And then the only issue is on the PMO contract. I know that there was a request that we hold that over, but I think what I'd like to do is suggest that we work with the PMO on these DBE, SBE goals. So I think that's probably the better way to do it, and I certainly will commit as board chair that we will work with them on that. So that may in fact be the most effective way to do it.
I think that's an excellent selection, and I will make that commitment as well.
Thank you. Okay, so the interim CEO and I will both have those conversations. Do I have a motion on the extension of the PMO contract?
So moved.
Okay. Second. Moved by Vice Chair Richards, seconded by Mr. Hartnett. Oh, yes, I'm sorry. Mr.
Let me just ask one question. Who do they report to? Who do the various contractors report to specifically?
If you read the papers, no one.
Right, but...
No, I'm sorry. Haven't had lunch yet, it's that low. Well, the contractors ostensibly report to the CEO of the organization.
Yes, the PMO reports to the CEO.
Directly to the CEO?
Yes.
Okay. That answers my question.
Okay. Anything else? Ms. Moore, please call the roll.
Vice Chair Richards?
Yes.
Mr. Umberg?
Yes.
Mr. Hartnett?
Yes.
Mr. Balganorth?
Yes.
Chairman Richard?
Yes. Okay. Ms. Padilla? And I know you're going to truncate your presentation, but there were a number of very important comments. Certainly, I'm going to guess that my colleague, Mr. Umberg, is going to be concerned about the disabled veterans and others. I don't want to put words in his mouth, but if you can address some of those to the best of your ability.
Thank you, Chairman Richard and members of the board. I'm very pleased to be given again the opportunity to kind of bring back the initial draft SB-DBE program back for your consideration after completing the public facilitation process. We are into PowerPoint. Pursuant to the FRA directives, as you recall, we are required as an entity as a direct recipient of the FRA funds to establish a small disadvantaged business enterprise program, and as such we have done so. In conjunction with that, we were required to put the program out for public comment. We did a very extensive outreach following the board's approval to release this on November 3rd, 2011. As you may or may not recall, we had a mandatory 45-day public facilitation process. You took the position to extend that in light of the holidays, and it was now increased to 85 days with FRA's concurrence to ensure that maximum participation and input was, in fact, secured. A number of modes were utilized to ensure that we got maximum participation. While the authority received extremely very beneficial number of responses, 235 submissions were actually logged during the public facilitation process. The submissions actually identified 456 individual comments that had direct impact as it related to the program. I'm not going to give you all the modes of operations that were used in the public facilitation process, but I would like to highlight a couple of them. One is the statewide public forums that were held under your direction in the city of San Francisco, Merced, and Los Angeles, where we had over 250 firms participating in those listening sessions where they heard firsthand about the program. We had the program available. The program was also available to be downloaded and to facilitate comments through our website, which was very beneficial and demonstrated significant contributions that were received in that manner. In summary, significant modifications and added value to this program were resulted from this process. Truthfully, there were a number of organizations, advocate groups, that really took to heart the program and really delved into it in many layers and in many areas. One of the most significant was the supportive services in looking at retention and success of a small business once they are selected and actively able to participate and successfully went through the bid process to ensure their success on the program. To highlight just a few of the key components of the overall program delivery that had an impact were, based on these comments, were to add stronger administrative and enforcement remedies to address contract or non-compliance. That was in addition to the board's directive to address these areas as well. The additional area that the board expressed in conjunction with many of the comments received was increased level of accountability by contractors who are currently doing work under authority contracts to ensure that they are in fact meeting the objectives and goals of the program and the utilization efforts. So we formally addressed the increased accountability, data collection and reporting of contractor efforts, and requirement of actual SB utilization reporting on a monthly basis. We also clarified a very important and most recently enacted final rule under 49 CFR Part 26, DOT DBE program best practice model, which now calls for and allows and permits set-asides for small businesses. So we did provide additional clarification as a result of many comments that were received on this area. The additional area was to enhance the authority supportive services model to include vital resource partners basically designed to leverage business development resources. We also imposed and expanded the contractor supportive services requirements to also promote success of small businesses participating in retention. Before you is a board action requesting you to approve the authority's Small Business Disadvantaged Business Enterprise Program as presented today, and corresponding resolution number 12-26, and provide authorization to the interim CEO to forward the program to the Federal Railroad Administration for their final approval and acceptance.
Thank you, Ms. Padilla. Mr. Flens?
Mr. Chairman, I know that the last meeting that we discussed this plan, the board member Umberg asked about the enforcement mechanisms, and Ms. Padilla just touched on that. But could I just take a minute and just read through those, because I've parsed them out of the plan, and just I'll read them to you quickly so that you know what we're doing in that vein. We have these following administrative remedies that we can choose: withholding an amount equal to the difference between the actual small business attainment and the contractor's small business goal commitment from any milestone payment until the breach is cured. Number 2, withholding up to the full amount of any milestone payments that would otherwise be due until the breach is cured. Number 3, requiring the submission of a corrective action agreement and presenting it to the board. Number 4, penalty of $1,000 a day for each monthly Form 103 that's overdue. 5, civil penalties for knowingly providing false information. 6, hold a responsibility determination hearing. And 7, termination of the contract in whole or in part.
Thank you, Mr. Flens. Questions, comments? Mr. Umberg.
Well, thank you, Ms. Padilla and Mr. Flens. I think that's a substantial improvement, and I appreciate you responding. I don't think it was just my concerns. I think they were concerns of the board. But for the price of time, I'd be more effusive, because I've looked at the plan, I've looked at the public comments, and you've done wonderful work in terms of soliciting comments and modifying the program to meet those comments. A couple questions, though, with respect to DVBE. If these were only state dollars, we would be required to set aside 3% DVBE, is that right?
Yes, and the program does speak to that. In instances where there is a 100% state-funded project, it does say that we will defer to the state statutes as it pertains to the Veterans and Military Code, and apply goals as applicable to those projects. So the 3% and the consideration of obviously even a 5% would be given consideration in accordance with those state statutes. Good faith efforts, we also mentioned in the program, will not be a requirement. If they do not meet the goal, they will be deemed non-responsive for award in that area.
But, well, it's not just that we would defer. We would be required by law to go ahead.
And I apologize. I may have, yes, we would have to comply with state statute.
Right. So if there's $1 of federal money, then it no longer applies. Is that right?
I don't know if you want to take this, Mr. Glantz.
That's correct. The state law just pertains to those projects that are funded 100% by state funds.
Right. But if there's $1 of federal money, then the state law no longer applies.
Correct.
Okay. Well, here's my suggestion, actually. I'm going to make it as an amendment, is that given the high unemployment rate among particularly returning veterans, and the state's policy as espoused by the governor, who's a strong supporter of veterans, as well as the legislature, that we go ahead and we amend the program that we submit to FRA, and we use the state policy and the state law as part of our program. So in other words, that if the FRA and the Congress and the executive say, we would prefer that California go ahead and use a lower standard, a lesser standard, that they can tell us to do so. My guess is that they won't. My guess is that they will go ahead and permit California to treat veterans accordingly, to have a 3% set aside. So with that amendment, I would move the proposal.
Okay. And I do have a question, but do I have a second for Mr. Umberg's amendment?
Second.
I mean, excuse me, for his motion as amended. Second? Okay. Just very quickly, I know we're running out of time. Ms. Lacombe and Mr. Guerrero were talking about something I discussed with them recently, which is just the ability to go beyond, to use bootstrap, certain other federal regulations, and so forth. Does anything that we do today limit our ability to amend or perfect or continue to do those kinds of things within the small business program, or am I going down a bad road here?
No.
No. Okay, so we can continue to work to do that. And second, because I'm going to want to see if we can get the next item in also, does staff have any objection to the expansion of the advisory committee by a few slots to add some folks?
No, we do not.
Okay.
No, there's no
Or at least
objection.
not that you're willing to express at this moment.
There is some issues of logistics, but we do not.
There's no objection to that.
Okay. All right. Okay, so on Mr. Umberg's motion to adopt the program with his amendment, that we include the 3% set aside for DVBEs. Did I say that correctly, Mr. Umberg? Would you please call the roll?
Vice Chair Richards?
Yes.
Mr. Umberg?
Aye.
Mr. Hartnett?
Yes.
Mr. Balganorth?
Aye.
Chairman Richard?
Aye. Could I have a motion on the next item, which is, I believe, the composition, the establishment of the advisory group?
Second. With the,
As expanded to 25 slots.
thank you.
Yes, thank you.
Second.
Okay. Would you call the roll?
Vice Chair Richards?
Yes.
Mr. Umberg?
Aye.
Mr. Hartnett?
Yes.
Mr. Balganorth?
Aye.
Chairman Richard?
Aye. Ms. Fonseca, Ms. Padilla, you guys do great work. Thank you very much. We're very fortunate to have you here. We appreciate it.
Thank you very much.
Mr. Flens, looks like we have about 15 seconds. I think at this point, the board will enter into closed session in the room behind us to discuss the matters that are on the agenda for closed session, both pertaining to litigation and personnel. Mr. Umberg?
May I just raise one final point, is that I've had a number of contractors, subcontractors, express concerns with respect to payment. So if we could put that on the agenda for the next meeting as to how we're dealing with payments to contractors and subcontractors, I suppose along the lines of what we discussed, what sanctions there are if, for example, contractors aren't paying the subcontractors, that kind of thing.
Right.
Be happy to.
Okay. That's good. And encouraging staff to have that discussion occur in the past tense as much as possible. So that'd be good. So we'll now enter into closed session. And I believe since we will not be able to avail ourselves of this facility, it's probably appropriate for me to say that we will report on any actions from the closed session at the outset of the next regularly scheduled meeting of the High Speed Rail Authority. Thank you all for your patience today. Thank you for coming.